right, good afternoon, ladies and gentlemen. It's time for us to get started. And before we get going, I'd ask Judge Scoggins if he would give us a 14. Thank you, sir.
Let's pray, please. Most kind and gracious Heavenly Father, thank you for the opportunity to be here today. Thank you for the opportunity to be here to do the work for the people of Georgia. We pray that you will lead us and guide us through all the decision makings we make today. Please be with all the people of the country of Turkey with the disaster that they're going through there now. Lead us, guide us, and bless us all. Amen.
Thank you, Judge Scoggins. All right. Several of the chairmen or the authors of bills are tied up in other meetings right now, so we have Representative New here who got her first bill through the legislature, out of the House, I should say, today, and did a very good job doing that. So, all right, you have, let's see, which one is it? 357. All right. If you would, tell us about that bill.
Thank you, Chairman. Thank you, members. I appreciate the opportunity to talk to you about House Bill 357. Now, this bill, I'm not married to this language. I will tell you that to begin with. There's just some issues. This is an old law. It just needs to be visited. So it's antiquated, and I just want to change the process, streamline the process for women. So this bill would change the process for individuals changing their surname, last name back to their birth certificate name. The people that this mostly affects is divorced women after the divorce is final. For whatever reason, they decide to go back to their birth certificate surname. I'm just trying to streamline how they would do that, because currently you would go to go back to your birth certificate name after you're divorced. You would go to Superior Court, pay at least $250 in fees or more. You have to run an ad in the paper for additional fees, and then wait your four weeks or so to go back to Superior Court, show that that's what you've done, to go back to your birth certificate name. This is a name that you've been associated with all your life. If you were to marry Mr. Smith, you could go to probate to the probate office, pay $56, which is what the fee is in my county. Make an appointment with Mr. Smith. Make an appointment with the. Well, you'd have to make it with Mr. Smith to marry. But with the judge, maybe a little bit more. Yeah. And you can make schedule it with the judge that day. Change a name to a name that's never been associated with your name. So HB 357 proposes a person goes to the probate court in their county, fill out the paperwork, it's like a marriage certificate, and pay the cheaper fee. Don't have to wait that time. Don't have to run an ad, and then they would process you back to your surname, your birth certificate surname. It's cheaper. It's a faster turnaround. There's no ads, and the people that are most affected by this are usually single moms that just wanted to get divorced when they were going through the process. And for whatever reason, they decided to keep their children's last name. For me, I wanted my last name to be the same as my kids. So I chose to keep that last name. So that's who it affects. They don't have this kind of income to pay to change their surname. After the fact, a lot of women just want to get divorced. And then after the fact, they're like, I don't want to be saddled with this name forever. There could be bad feelings. There could be, emotional feelings that come with that. It's very much a woman's identity, and they just want to get their identity back and not have to run an ad.
Sorry.
That's the bulk of this bill, and I will take any questions at this time or suggestions.
Representative Scoggins.
This is going to be kind of funny, but did you use the name Smith because you wanted to give Chairman Smith a lesson on how to change a name, and he just got engaged and got a fiance? So we wanted to know if you're just using that name Smith for that. Okay. Just pointing a little finger.
Representative Oliver, is that you?
this is a real issue. And currently in the Superior Court, when you get a divorce, you can change your name without a legal ad and without. So that is available with the one filing fee of divorce. But there are other reasons that people want to change their. And this is a new way to do it. I'm looking at line 49. Shall not charge a fee for application of certificates of name change. But then if you look at line 34, shall issue 5 certificates. I know my probate judge I would be confused about what she can charge for the original application fee, and then there might be an inconsistency here, and the council probate judge fee is scheduled. We don't have anything equivalent to it because this is number of pages. It's usually number of pages that they charge by. So I'm trying to figure out the fee. The big change from my perspective is that, as a policy consideration, is that you have no legal notice, so there's no opportunity for anybody to say this person is doing this for fraud purposes. In the divorce, they don't have a legal notice change either. So,
When you get married, you don't have a legal notice change.
right, exactly. So it's an issue. It's a problem. I just don't understand how the fees are being charged in this. Can you say there's no fee and then you have to issue and then there's I don't know what it means. I'm a little confused with that.
I'm not much help. I didn't do that kind of work.
But you approve name changes for lots of reasons.
In divorces, yes.
But not in other. I have people coming up wanting to change their name for lots of different reasons. And
Yeah, but yeah, the ones I'm used to are the ones where they advertised and
right,
did what they were supposed to under the current law.
right.
So. All right.
Mr. Chair. So on that note, what did you intend to do as far as the fee goes? Did you intend for no fee for the first certificate and then they can charge additional, or did you mean just there's no fee, period?
Well, I took out the fee, the original bill had a $50 fee in it, but I went back and I said, different probate judges charge different fees. Mine is 56. I'm not sure where yours is on the fees, so it would be up to the probate judge, whatever their fees are, basically for a marriage license. Because when you get married, or when you go to get a license after you've been divorced, you have to bring your birth certificate, your marriage license, your divorce agreements to get a new license once you marry again. So you're bringing all the documents that she would need anyway. And that's why I was thinking that it would be easier to go through probate. If there's a place to put it on Superior, that we could waive some of those fees where it would be less expensive and get rid of the time constraints, I would be open to that as well. Just to streamline the process for these women.
All right.
There is the probate court is used to processing these things, like marriage certificates and processing, sending it to the people that it needs to go to, so that's why I was thinking that might be a good solution for this problem.
If I recall, there's a procedure for individuals who've gone through domestic violence to do this without advertising, under current law, I think. That's what I seem to remember.
And that would be under Superior,
In Superior Court, yes.
so you'd still be stuck with those fees.
I don't know. Since I was on the other end of the receiving of documents, I didn't have to deal with that part of it.
I believe there is, Judge, there is a portion of like victim and family violence.
Yeah. But that's the only exception to the, yeah. Okay,
It's just waiving publication.
okay. All right. Any other discussion? Representative Scott?
Representative New, I think we may need to get with the the clerks of Superior Court and the probate judges together and try to get a compromise for that, because I don't know that each one of them would know what their duty is the way the bill's written now. So, and the fee process. I think we need to get with them and see if we can work that part of it out. But I like the concept of the bill, but there's some issues there to work out.
So your direction would be to reach out to Superior and
Clerk of Superior Courts and the probate judges, yes, ma'am. Okay.
Is anybody here today from either of those groups? All right. We'll work to get you in touch.
I did reach out to Alec, the group, and there is no precedence, so there's no template for us to work with. Alec,
Representative Oliver.
I think the good idea to figure out the fees, because there's no equivalent in a probate petition here. Is this a petition or is it a license? And so I'd like their guidance on it. The real question is whether or not we have any interest in the original intent of a legal notice was to prevent fraud. If I want to rename myself Britney Spears for the purpose of signing her name on checks, there would be a legal notice and Britney Spears' lawyer might see that. So that's really the policy issue that we're changing.
this bill would not, this has to be your surname from your birth certificate. It's very specific. So if you wanted to, if I wanted to change my name to Susan Brown, it's never been associated with my name, so I would not be able to do that.
Okay, well, I didn't catch that. That's important. Yeah, thank you. That helps. Thank you.
Representative Hong, you wanted to? Oh, okay. All right. Any other questions? I tell you what, I think I'll just make this hearing only for now and give you a chance to come back to us maybe next week early. Okay. All right. Okay. Representative Daniel. I don't think we have anybody else.
Yep, she's in.
Come on. All right. Good afternoon.
Hello, thank you for having me.
Sure.
Oh, wait, that mic's dead. Use that one. Yeah.
All right. Representative Daniel, for those that are watching us, introduce yourself and then tell us about your bill.
Okay, so I'm Representative Lauren Daniel from the 117th. I'm presenting House Bill 298 today, working from LC 491220. The purpose of this bill is to provide an exemption for natural or adopted mothers of children 6 months of age or younger to be exempt from jury duty. Should be a simple bill, but I am also open to a friendly amendment to include parents instead of just limiting it to mothers, if that's the will of the committee.
Okay, so you're asking to put into law that this is an exception to your jury duty service.
Yes.
So, okay. All right. Any questions by the committee? Oh, sorry. Representative Reeves.
Representative Daniel, on line 11, would striking mother and replacing it with parent, would that be the friendly amendment you're looking for?
I believe so.
All right.
Also
13 as well. Strike mother, replace with parent on line 13. Okay.
And
Rep-
line 3 as well.
And line 3. Isn't there already a small children or young children exception to jury duty? Nursing?
I believe so. I think it is limited to nursing. I think that excludes some parents that may not have chosen that route.
Okay. Because I remember some that when we were doing voir dire of a jury, if they had children of a young age, they were excused already. And I'm trying to remember, I don't remember the statute on that, but I know it's out there.
Yeah, it's still under this.
All right. So, Representative Reeves.
Mr. Chairman, if there are no further witnesses, I have a motion when you're ready.
Okay. We got one more over here. Representative Smith, you're holding it down there.
Yeah.
All right, go ahead.
Did we figure out the answer to your question, Mr. Chairman?
I don't think so. It seems to me that there's a statute out there that gives them an exemption already, but
It's
Representative Hong?
yes, Judge. It is the same section, and it's under 3,
Mm-hmm.
A3, and it says any person who is the primary caregiver having active care and custody of a child 6 years of age or younger.
So
It's
that could be a
exempt.
grandmother.
So it could be a parent, grandmother,
Uh,
parents. Yeah.
And Mr. Chairman, I just found that. Thank you, Floor Leader Hong. It also requires an affidavit on a form provided to the court. I've actually done that for a constituent of mine that was a primary caregiver for her mother, which is elderly, not necessarily like this, but it can be done that way free of charge, obviously.
Right.
So, I mean, arguably, I'd say it's already covered for in law.
All right, any other questions from the committee? All right. What's the posture of the committee with Representative Reeves?
Mr. Chairman, I have a motion with some friendly amendments. I think the specificity is good, and move do pass with 3 amendments.
Is there a second? Representative Kelly.
I'm just completely supportive of the idea and the concept. I want us before we debate whether we need to add language to the statute, just need to see whether it's covered already under law, and if there's situations where it's not, I'm open to hearing those. But before we get into debating and making motions or additions, I think we need to figure out whether we need to do it yet, or if we already have this protection. And that's what, if I could get some guidance maybe from legal counsel as to interpretation or necessity, that would be.
This, Mr. Chairman, the distinction is the provision in the affidavit that you're the primary caregiver. That was what would distinguish this. This is almost a status exception for the first 6 months of the child's life. If you are the child's parent, you just are exempt, even if you're not willing or able to complete the affidavit saying you're the primary caregiver. Just the fact of being the parent is what distinguishes.
But how do you show that to the court? You're still going to receive a notice to come to do jury duty.
And there is still an affidavit requirement. You just don't have to attest that you're the primary caregiver for the child. You just would establish that you were the parent.
Okay, so if you're not the primary caregiver to the child and you have a young child, you get exempt from jury duty? Is that how this works?
That was,
Do you see the problem? Well, if you have a young child, doesn't matter if you're the one that's the primary caregiver for the child, you get exemption from jury duty, whether you can serve or not.
What if you don't live with the child?
I think the intent of this was to cover the parent that is of a new child. And there are a lot of responsibilities that you deal with when you have a new child. There is a lot on your plate as it is. hate for them to have to go through a strenuous affidavit process to.
Okay, so when somebody doesn't show for jury duty, a judge has the option of sending an order out that they are to appear before the judge for a hearing on contempt of court. So if we don't have a way of notifying the court that you have a young child, that's what's going to happen.
I think the assumption here would be that in order to adopt a child or give birth to a child, you would have a certificate that said you gave birth or adopted that child, which would make you the.
But you got to show proof of it in some way. Yeah, which we've already got by affidavit.
Yeah, and it's in this statute, in the proposed legislation, it would have an affidavit requirement too, and so that's, I guess, Representative, have you got an example for us of where a natural or adoptive mother, because I mean, at least from what I'm hearing, they have an exception today. I'm just trying to figure out if somebody been denied that exception, and if that can help us get the proper language.
Right, so I can't speak to how long ago it was or when, I mean, you guys might know, you might be in school when this was enacted, originally, but my daughter's kindergarten teacher actually had this happen to her, and so she was a proponent of this idea, because she was like, I was having to bring a brand new baby to jury duty, and so I could nurse it and had to have the babysitter sit outside, and obviously that's a undue burden.
And I agree with you. That just, the statute that we have today doesn't seem, Judge, you,
Well,
because they would be a primary caregiver,
right.
clearly,
It's just
under 6 years of age.
how do you notify the court? That's the question.
Right.
So,
I mean, I always imagine you get the notice, and then you get to the clerk of court and you sign the affidavit.
that's current law. All right,
Yeah.
Representative Smith.
Thank you, Mr. Chairman. So when I had this happen over the last 6 months, I turned that affidavit into the clerk, who would note that, who is responsible for handling all the jury summons, making sure that people have responded, and they, as the custodian of such records, that's who you submit this to. I mean, right now the law as is, and I know this wouldn't necessarily limit what Section 3 of the statute says, but in Section 3, I mean, the primary caregiver, I mean, that's someone having active care and custody of a child 6 years of age or younger. So that's all the way up into age 6. I mean, having that requirement, I mean, I think that covers it. And so just to hypothetical it, if somebody, let's say the mother spends the first 6 months with the child, and then the father spends the next 6 months with the child, or any period up until they're 6 years old, I mean, if they're swapping turns taking care of the child while the other one works, or somebody's out on, like, let's say, family leave, this would be covered. So I don't think the reading of the statute would necessarily limit it to either the mother or the father. It could be both, whatever the situation may be, just upon a plain reading of the statute, but I'll defer to the judge on that.
No, I think that's correct. All right. Representative Reeves. Oh, I'm sorry, you have a response.
Okay, so, you guys might be able to speak to this as attorneys. Is there anything that requires, I guess on the notice that you get to serve on jury duty, that it lists this as an exception? Because if it goes up to 6 years, I can actually speak. I served on jury duty when my children were younger than that, had no idea that it was an exception, so is that something that's listed?
But did you have somebody that could help care for the children while you were serving?
My husband had to take off work, yeah.
Okay. Representative Reeves.
Mr. Chair, in looking at subsection 3, it says that's for the 6 years and younger. If you're the primary caregiver and then you certify you have no reasonably available alternative child care, then you can be excused. Representative Daniels' bill says no matter the circumstances, if you have a child 6 months or younger, if you're the parent, then you can get exempted when you sign the affidavit, period, just saying that you're a parent. Now, I'm sympathetic to that because my youngest is now in 7th grade, but I remember with my 3 kids, those first 6 months, the parents are getting used to the baby. The baby, is, having illness. If they're in daycare, they're getting sick, and, you're getting them better. And so if someone gets called for jury duty on a week or 2 trial, the likelihood that their service is going to get disrupted during that service the first 6 months is high. So we do have alternate jurors, but I think letting these 6-month and lower parents off jury duty if they fill this out and present that they, want to be excused is a good idea, because it could disrupt more trials, whether or not they're the primary caregiver and have an alternative. If they have some emergency with their 6-month baby, I think that could interfere with the progress of the trial. So I like the idea of this, and I think it's broader than subsection 3, and it doesn't have as many restrictions as subsection 3, and I think that's a good idea for parents with a baby 6 months or younger.
Okay. Representative Oliver.
Representative Kelly has just handed me the statute, which has a number of different references here. I just want to make sure what this doesn't weaken the law here, or make any inconsistencies. That's what I'm concerned about. And I just can't know that right now. And I'm a co-sponsor, so I should have researched this before I came here today. But I'm concerned about the inconsistency. This does allow, this focuses on children, but also other relatives, taking care of elderly parents. I'm not sure how much we're creating inconsistencies or changing the law.
Okay. Let's see. Representative Bruce.
I'm just trying to make sure I was listening to what the gentleman said. Will we be, in the net effect, reducing the benefit that already exists by passing this bill? Wouldn't we be reducing? We would be taking away.
I don't think so. I don't think we'll reduce it. You still have the 6 years and under. You just have to do an affidavit. This is for 6 months or younger. You have to.
Right, that's what I'm saying. If they already have 6 years now, or less, if we pass this bill, will we not be taking the 6 years away and replacing it with 6 months?
Right. You still have the 6 years because you have to give an affidavit. But in this one, you don't have to do an affidavit. You just automatically get it. And what I'm trying to figure out is, how do you notify the court that that is your status?
Right.
All right. Representative Hung.
Yes, Representative Daniel, just follow me here, and I may be just talking out loud. Okay. If I am a mother that just gave birth, this statute covers it, correct? Or this bill covers it, correct? Okay. If I am a mother that just gave birth and I'm a caregiver of that child, this bill covers it, correct?
Yes.
Okay. If I am a mother, if I just gave birth and I am not the caregiver of that child, this bill covers it, correct?
Potentially.
So if I do not have custody of that child, if I do not have that child in my home, but I gave birth to that child 6 months or before, this bill covers it, correct?
Potentially, I think that it would depend on the rules of birth certificates. If I have to guess, I'm not certain on whether or not if a natural parent retains the birth certificate for a child.
I'm not saying anything about adoption or anything. What I'm saying is, if I gave birth to a child and I happen to the father of the child and I do not live together, and the father is taking care of the child, me as the mother, and I live alone, but I gave birth, does this cover it?
I think so.
And I don't have that child in my home.
Potentially.
Representative Kelly?
I think I'm just going to defer at this time, Mr. Chairman. I think I understand the need to have a exception, an increased exception, excusable opportunity for a mother, father, natural or adoptive. I understand it, and I want us to help get there. I do see where subsection 3 is tighter. I think there may be some language we could come up with that goes into subsection 3 instead of adding on a sixth exception, just so we don't look like we're creating inconsistency in 3. But I understand what Representative Hong is saying, as well as because there's nothing in here to make sure that they do actually have to have custody of the child. I think there's some language we can get there. I just don't know if we want to try write it on the fly. If you want me to, I'm glad to sit over here and try and do that. I've done it before and it's worked out about half the time. Or I'd be glad to work with the author or whoever to try and get it ready for the next time we meet.
All right, let me just read this thing. Any natural or adoptive parent of a child 6 months of age or younger who executes an affidavit on a form provided by the court stating that they are the natural or adoptive parent, if we make that change, of a child 6 months of age or younger, and who requests to be excused or deferred, shall be excused or deferred. So, and current practice in court is that, if you've got a good excuse, no matter what it is, the court will give you a deferral the first time. Usually, a lot of times I gave it when you didn't even have an excuse. You just wanted to wait until the next time to be called up. So it's not that hard to get at. Okay. Representative Silcox.
Thank you, Mr. Chairman. I guess in my own mind, I had envisioned that this could be put, I know when you receive a jury summons, it gives you reasons for excuses on that summons, and that the court just administratively could add language on that jury summons to say that one of the excused absences is if you have a child 6 months or younger, and the form for the affidavit could just be, in a link that was referenced on the jury summons form. To me, seems administratively the simplest way to do this.
Does the jury summons form already have the
Excuse.
exceptions
It does.
listed on it?
It sure does.
All right. I've never served on a jury, so I don't know.
You need to come to Fulton County, and if you vote in Fulton County, they'll come get you.
All right, Representative Smith.
Thank you, Mr. Chairman. I would be very interested in seeing what case law may say on this point as far as what the definition of a primary caregiver is. Because I stayed with my two grandmothers a good bit during the first 6 months of my life after my mother was fired for having me. So, I mean, I would be very careful before even attempting to amend the statute, because depending on what the definition of a primary caregiver is, I mean, I don't want to speak too soon without having some case law in front of me, but I mean, primary caregiver, that may be so broad as to cover situations we need to cover already, up until 6 years old. I'd be very favorable to providing that on jury summons forms or whatever the information sheet given to jurors is. I mean, if we need to statutorily require that, I'm all good with it.
All right, seeing no questions, what's the pleasure of the committee? All right, we go to Representative Kelly.
I'm going to make a motion to pass, Mr. Chairman, just to keep the conversation going. If you want us to look at considering amendments, or if you want to have I've got something written over here. If we want to look at adding something on the subsection 3 to try and get it done today, think I've got something at least working, or if you want to, I'm gonna follow your lead here. But if you want us to try and get something done today, I'll make the motion do pass and try to help come up with an amendment.
All right, I have a motion and a second.
Or I'll withdraw that, given the chairman's inclination.
I'd like to have something right now. Your motion applies to LC 49221220.
And then I was going to offer an amendment if you want to do that, or I'll be glad to work with legal counsel and the author to try and.
We can discuss that. So
Okay.
All right, I have a motion and a second. Representative Reeves.
And I'll defer to Representative Kelly on amendments, or I can give some.
Are you prepared to make a motion for an amendment?
I'm ready. Yeah.
All right. Go ahead then.
So I think what I'll do is I'll just strike in the entirety lines 11 through 15. And then we're going to have to get into the subsection 3 of 1512 1.1a. And then I would strike the period in subsection 3. And insert new language. It says, provided, however, if said child is under the age of 6 months, any natural or adoptive parent who has custody of said child and requests to be excused or deferred shall be excused or deferred from jury duty.
If that's offered as an amendment, I'll second it.
All right. I'll tell you what, let's suspend for a moment so we can get a copy of that and get that out to everybody.
And we probably need to add the new language, or we're probably going to need to include the language of 3 with underlining what I just said. Do you want me to come back there and I'll come back there and type it up.
We'll stand at ease for just a few minutes.
Do you like that? Okay. Is that good with you, Matt?
Good.
Okay.
Just that one. No reading.
Got it. Okay.
And the caption.
Got it.
Okay. Doctors
All right, Representative Kelly, I'm gonna turn on your mic. This is, we have it in writing, I think, and is this accurate as to what your motion was?
Yes, sir, Mr. Chairman. We did have to, in the author's original bill, there was still an affidavit requirement. In the original subsection 3 for primary caregiver, there was still an affidavit requirement. We just wanted to make clear that this is still requires an affidavit that the court will provide. And if I can read it to everybody, the amendment would be in the section 3 now, provided, however, any natural or adoptive parent of a child under 6 months of age who executes an affidavit on a form provided by the court stating that such child is under the age of 6 months and he or she has custody of such child and who requests to be excused or deferred shall be excused or deferred from jury duty.
Okay, all right. So on that language, we have a motion and a second. Is that correct?
Correct. Is that
Okay.
we get to the author?
All right. Representative Daniel, do you have anything you want to tell us on that?
No,
Is that-
I agree with it.
You
I think
agree
that-
with it?
I think that
Okay.
fits the intent.
All right. Any other discussion by the committee?
One thing, Mr. Chairman, we went on in this Amendment 2 as it was drawn up and also just cleaned up the title where it said we're not adding a new section and cleared it from natural adoptive mother to natural adoptive parent. That was not discussed. It was discussed by Representative Reeves, but that's just clearing up the title that the match what we're actually doing here. So.
Okay. Well, we don't have a motion on the striking mothers and inserting parent yet. We'll have that motion here in just a second.
Okay.
We discussed that.
It was written on this. It was just included on this.
Oh, it is? Oh,
Yes,
there
sir.
it is up there. Okay. All right. Well, we'll get to that in just a second. Okay. All right. So what we're voting on is the language that Representative Kelly just read to us. And on the sheet that you have, it's under Section 1. And it just takes the language from the original bill and does not create a new subsection, but adds to paragraph 3 in 1512. I guess that goes 1512.3, right? Okay. Yeah, well, I don't have the whole statute in front of me.
1512 1.1.
1.1 A3. Okay. All right. All right. Any further discussion on this, Representative Reeves?
One idea, just label this document we did, since we don't have an LC number, let's label it and we can do the motion on that since we've got it all in writing.
Yeah, that's what I'm gonna write on it. All right. Any further discussion? Hearing none, all those in favor of amendment number 1, say aye.
Aye.
Any opposed? All right, amendment 1 is adopted. And then on that same sheet of paper at the top is what we'll call amendment 2. And this basically just replaces the word mother with the word parent. And it does it in 3 spots on lines 3, 11, and 13 of the original bill.
Chairman, 11 and through 15 were struck and were replaced by what we just did in
That's
Amendment
correct.
1. So it's just replacing it on line 3.
Line 3.
Yes, sir,
Okay.
Mr. Chairman.
Thank you. All right. Any further discussion of that amendment? All right. All those in favor say aye. Any opposed? All right. I believe we have a motion to do pass. Any further discussion on that? Good. All right. All right, hearing no further discussion, all those in favor of passage of LC 491220 by amendments, say aye. Any opposed? All right, your bill passes.
Thank you.
Yes, sir. Representative Petrie, if you would. Casey's not here yet, right? Okay. You gotta go.
Judge.
Oh, about through. Okay, all right, very good.
Thank you, Mr. Chairman.
Yes, sir. If you would, go ahead and,
Yes, sir.
for those at home, introduce yourself and then tell us about
Yes,
the
sir.
bill.
I'm Representative Jesse Petrie. Represent Chatham and Bryan counties on the Georgia coast. And I bring you a bill today I really need your help with. And you'll see here, all of the signers on this bill are basically the totality of our coastal delegation. If one of those guys that you see there at the top of this bill were a lawyer, they would be here presenting this, I suspect, because it'd be a lot easier. Because we're dealing with, me. We're talking about quiet title, and I'm not a dirt lawyer. But I will tell you this. I or any of my colleagues can well explain the problem we're trying to address here today. And so I really do want to tell you up front, Mr. Chairman, we need your help. We need your guidance and your counsel. This is the place to get it with all of the attorneys that are here and the experience that we have in this room. I'm hopeful you can help us. So let me tell you what our problem is. So we all know, and I'll try to frame it the best way I can, we all know that going back to common law, it's presumed that on the interior of this state, all land at one time came from a grant of the king or the state. And there's a presumption that if you hold title to that land, it's yours. It begins there. The inverse is true when you go below the high water mark on the coast, where the presumption is that the land belongs to the state, unless somehow you can prove you have title back to the crown or the state. So that is the issue we're talking about today is the issue of king's grants. When I say king's grants, I'm also talking about state grants. Because what you discover, and most people don't know this, what you discover on the Georgia coast is that we have tens of thousands of acres on the Georgia coast where the marshland is actually owned by private individuals. Now, I wish that wasn't so, but it is so. It is a fact. In fact, there's probably about 36,000 acres. If you look at an aerial photograph of the Georgia coast, you're going to see about 36,000 acres that have been altered by man. So they've been ditched, they've been canaled, they were largely rice plantations, things of that nature. And if you can imagine, if you would, individuals who were going to develop that land for farming, we commonsensically know they wouldn't do so if they didn't hold title to it, right? You're not going to make investments into all of the ditches and so forth and canals and gates and things that had to be done. So you're only going to do that if you hold title. So again, tens of thousands of acres of actually not just the uplands, but the marshland of the state are in King's grants. So as long as I've been in office, I probably have maybe 2 constituent issues a year. You're not going to hear about them constantly, where somebody is complaining about the current process of trying to establish their right to that land. Now remember, their right to that land may be for something like I had this summer on Tybee Island where somebody wants to build a dock, okay, and they're being told you can't build a dock. Well, they believe, and they've been working for over 7 years now, which is what we're going to talk about in a moment, they believe they have clear title all the way back to the king, which would allow them to build that dock, right? And to do whatever they want with it. So there's a process for trying to do that, and that process is extremely cumbersome. It's extremely cumbersome. And so what I hear from my constituents Again, not every day, but occasionally. And what I hear from my land resource manager, people that advise them, and what I've learned from the folks, the people who specialize in searching titles back to King grants, particularly a man by the name of Ferris Cadle, who's one of the most well-known in the state, is that the process forever and ever, which requires seeking a remedy from evidence, providing the evidence of that line, that lineage back to the King's grant, and the seeking a determination by the Attorney General takes years and years and years and hundreds of thousands of dollars. You're paying consultants. And so what happens is people are frustrated. And, if Representative Loach he's presenting a bill right now. I wish he were in here because he's had many examples of this over the years too. Haven't been born and raised on the coast as I was. I think all of our guys on the coast would tell you about this. So what we're trying to do here then is to create a new way, a simple way, a more efficient way, so it doesn't take 7 and 5 and 6 and 3 years. Even if somebody produces everything they need to prove title, that gives them a more expeditious path to prove this, if and only if they encumber it, and we'll go through it in a second. They must, if they use this new path, encumber the totality of that land to include the uplands, which normally would not be encumbered. They have to say every bit of it must be dedicated, as you'll see in this bill, for conservation purposes. So it would all be protected. Now, why do we want to do that? Because first of all, and we call this the Coastal Marshland Restoration Act. First of all, nobody's restoring those tens of thousands of acres on the Georgia coast to its, you can only imagine. So those of you that aren't from the coast, the marshes of our state, the creeks meander. It's the way God made them. That's not what tens of thousands of acres on the Georgia coast looks like. It looks like this, looks like hash marks. You can only imagine that's not good for the fishery. It's not good for the environment. It's always, when we try to alter the landscape, we make mistakes, don't we? And we certainly did back then in colonial times and early statehood. So if we're going to get those properties restored, there's a way to do that. And the way to do that is many people will use them for mitigation credits. Y'all are probably well aware we need a lot of mitigation for dredging the Savannah Harbor on a regular basis. Okay, and so the mitigation of all of those thousands of acres of marshland, they're used in this way. When someone can establish, and there's one that was established recently, a gentleman worked for, 10 years, finally got the Attorney General to acquiesce and accept his title. And then I think they ended up taking some of the credits in order to negotiate that. But that land was used for mitigation. And so what they'll do is they'll go in and rectify the damage that was done to the marsh. So first of all, I want to make it very clear, because my family have been on the Georgia coast since the Revolution. Okay? I'm going to tell you, I will not do anything, and I don't want you to pass a bill. I would never want you to do anything that would harm the marsh of this state. So to be clear, this is not to let anybody do something to the marsh that they can't do now, because every bit of our marsh is encumbered by the Coastal Marshland Protection Act of 1970, every bit of it. That's already the case. Whether you have a King's grant or not doesn't matter. You can prove a King's grant to a piece of land. You can't do something with it that violates the Marsh Protection Act anyway. But here's what's happening. The cumbersome process that exists today makes individuals that have been paying taxes maybe in their family for 100 years on these tracts. Everybody is glad to take their taxes to recognize it's their land. They're paying taxes on the totality of this land, to include the marsh. And then when they want to do something with it, like use it for mitigation credits, then they're told they can't prove it. And so they have to spend a fortune, $200,000 to $300,000. I've talked to Mr. Alton Brown, one of our most notable resource consultants down around Savannah. It's good for him, But he's given me all the horror stories and others that do this for a living. Meanwhile, it's the delay that goes on. And so what we're trying to do here is to create, if someone puts all of this land in a conservation easement where it can only be improved for conservation, can never be touched, so that nobody has to worry about the marsh ever again, right? If they agree to do that, we give them an expedited path. Now, what the expedited path allows them to do is to present all of the evidence, because, listen, you either have it or you don't, and if you don't have it, I don't want you to have it. If you can't prove title, then the ruling needs to be you can't prove title. Get out the way. But what's happening is this constant and chronic delay. And again, I'm going to do the best I can to speak to the quiet title provisions would be, best for someone else. I'll do the best I can. But clearly what we're trying to do is to create a framework for a better path to seek quiet title, knowing there's always the path that exists to seek quiet title as you would customarily, right?
Let me ask you a question at this point. So if I'm wanting to prove my ownership of the property, I have to link it back to
Yes,
either
sir.
the state grant or the King's grant.
Yes, sir. You have to do
All right.
that first.
And what's the current process about how you do that? Do you show deeds? Do you show transfers through like the probate court? And
Yes, sir. The best I can tell you is this: so the individual is paying someone to do the research to prove the chain all the way back to a King's grant, or what many I learned, probably half of which are state grants. They were granted by governors and in early statehood, and so they have to prove that. So remember, if you don't have that, that's fine. We want somebody then rule that way. But that's not what's happening. So yes, we want the individual has to prove that first before they begin this process.
Does the current process require that you go all the way back to that grant?
Yes.
Okay.
Yes, sir.
All right.
It does indeed.
Okay.
Right.
Thank you. Yeah.
Yes, sir. Thank you, Chairman.
All right. I've got a question from I think Representative Evans.
Thank you, Mr. Chairman. If there have been, what have been the reasons that have been given by the AG's office or whoever's undertaking this as to why it's taking so long?
Yeah, so I'll do the best I can to answer that from what I've heard from constituents and others and some of these consultant managers. So what we're told happens customarily is this, and I wish that AG's office were in here. And listen, I've had the AG's office is fine with they've not opposed this. They're like, hey, we're just doing our job. But so here's what I hear. I hear that the individual provides all of this. They've paid someone to do all of this title research and to prove it. And then, months and months and months go by, or longer, because almost everyone I talk to say they've been working on it for years. And then they come back and say, well, on this particular chain here, from this one to this one, it's not clear. Now, I'm just giving you best examples I can of what I've heard. It's not clear here, so we can't accept this. But they tell me, to them, it's legible. Or they will find a circumstance where there wasn't an issue, and so then you go to the next issue, and it's like every time they come back with something new. So the people believe they're intentionally being delayed, that the department is intentionally delaying these, and they simply don't want to grant any of them. Now, and so, first of all, the common folks aren't going to be able to go through this process that we just described anyway, because they make it so, and which is what we're trying to get to, they make it so difficult and expensive that a common man would never be able to spend the fortune or the time to do this. And so I think that's unfortunate, because if they have it, they have it. Now, again, we don't want it to ever be abused, and I know I keep mentioning that. And I do that only because there's some people that might perceive this differently. Oh, you're granting private land of the marsh to individuals in the state. Well, no, we're not. They already own it. This was done back before our time. We're trying to clear it up and clean it up and then restore it.
And your bill only, this fast track in your bill only applies if folks are trying to put it into a conservation easement anyway.
Yes, ma'am.
Which means essentially
must.
the status
Even
quo
uplands,
is sort of
even the uplands, which
reserved.
I added because the environmental community felt more comfortable with that, and I said fine. So the hammocks, the uplands, even the uplands that wouldn't normally be encumbered would be encumbered in the conservation easement.
Okay. Thank
So
you.
they could not be developed or in any way.
Representative Reeves.
Representative Petrie, a couple of questions about this. So this is creating a specific quiet title procedure for coastal marshlands, right?
Yes, sir. That's
And quia timet quiet title. We've got Latin and real estate, so that's how it ended up in Judiciary.
yeah. Please don't use Latin on me. Though.
Under the statute, a couple of times, or under the bill, a couple times, the State Properties Commission is included. I'm wondering, would it be a good idea to also have the Attorney General's office and either the district attorney for the circuit the land's located in, or the county commission for the county it's located in, to be notified also? State properties.
Yes, sir. Excellent question.
State properties, I don't know if their antennas are up on this, but I would
So
imagine.
let me speak to why we
Sure.
changed that. Thank you, Representative. Very good question. So here's what we have. Today it goes straight to the Attorney General's office. And historically, as I said, there's been delay after delay after delay. I've had some acknowledgement of that, even by the department, that historically there were delays. But here's what the reason we changed that. The reason we changed it to where they provide this to the State Properties Commission was so that then the Attorney General's office would represent them, because the Attorney General's office has to represent the state. And so the Attorney General's office themselves felt like this was an improvement to the process, that it would go to the State Properties Commission, who then would be represented and defended by the Attorney General's office. Does that make sense?
And whoever is named at the party as the party, I'm undecided on that, but I think it still would be a good idea to serve the Attorney General's office, even if you're serving the State Properties Commission, in case you have a commissioner or a person who gets it and doesn't know what they're looking at. Have an extra layer where the Attorney General's office, who does real estate decisions, where they get to look at it. And then I know that district attorneys get to look at bonds and certain proceedings, and then county commission offices look at real estate in their county pretty frequently. I think having that additional layer of eyes on it might be a good idea, and just wanted to put that out there.
Yes, sir. I would be supportive. I think that here in this body, we could probably get a lot of good ideas. I would trust the judgment of this body. I hope I've explained what we're trying to do is to give people a route forward where, again, they have to be told yes or no. And if you're told no, that's fine. But the chronic delays are inappropriate. Government shouldn't treat our citizens that way. There should be some standard of promptness.
Mr. Chair, one follow-up.
Sure.
You mentioned conservation easement tax credit. That's one aim of the bill, possibly, to get clear title to get that. Is that
restoration projects? It would all be encumbered by conservation easements, some of which could be used for restoration and mitigation. Yes.
And you mentioned that the use of the land is restricted. But is there any benefit of getting clear title of that marshland to have a property owner who's got an incentive to care for the land, in addition to whatever regulatory restrictions there are? You know, I always think of the tragedy of the commons, and we have a high tide in Savannah and the coast of 10 feet or more, which is unusual. But would it help to have a property owner who has vested clear title to care for the land, in addition to whatever regulatory restrictions in place? Is that part of this, or is that just kind of a non-issue? Non-issue. All right. So really, this is about conservation easement tax credits. Is that kind of the
It's
bottom
about
line?
that, and I mean, again, there's there are people that have other reasons for wanting to clear their title. So
What are those?
I pointed to the Tybee example I had just this summer from a constituent who's been trying for 7 years to get a dock. But at the end of the day, this issue expressly relates to conservation use.
Who
Correct.
are they having trouble getting the dock from? Is that Army Corps?
From DNR.
DNR.
From DNR, and that would be related. But they would be able to do what they want to do with the King's Grant. Again, I mentioned that only to give you examples of what we hear on the coast from our constituents as it relates to King's Grants. This measure is focused on conservation easements. So that's a little bit, I mean, I'm just showing you the multitude of examples we have about King's Grants. It gets very complicated. But this measure is about restoration of coastal marshlands.
No. Representative Leverett.
Thank you, Mr. Chairman. So I've done a little quiet title action work in my practice, though probably not very well, but I have.
More than I have,
And,
Chairman.
So it sounds like this is gonna go in some of the quiet title provisions of the code, so this is gonna be another special kind of quiet
Yeah,
title.
right.
Where you're actually dealing with marshland, ownership of marshland.
Yes, sir.
So there is a provision that requires service on the AG, because we amended it last year, but it would not arguably apply here. So if we did want to require that, which is not a bad idea in my view, that might be something we need to add.
Okay.
But otherwise, it appears this is just kind of tracking normal quiet title procedure, except we're adding sort of a kick of submitting sort of an abstract to the State Properties Commission in advance. I think it's, because you do that prior to filing a proceeding, I guess, to put them perhaps on notice, or to get a certification that you've got sort of the grant.
Yeah, it gives them 180 days to just, which we believed was fair, and again, I accept the will of the body, but we believe, just provide it doesn't tell them you have to agree, but you have to provide some answer.
Right.
And
you
to
have
keep
a
these
special
chronic
master
delays, and you have a special master. That's
appointed
correct.
to make findings and report back.
Correct, like you would more in a customary
So
case. I'll
this
use that
appears
term.
to be sort of premised on existing state procedure for quieting title. It just creates a little special category because the nature of marshlands is so unique.
All right, I have a question for the dirt lawyers on the committee here. On page 7, lines 139 through 142, and especially on 141 where it talks about 40 years back, the title standards just for a regular piece of property is 50 years. Is that correct?
By the Georgia title standards, which aren't adopted by law, but they've been
Right.
pretty sacrosanct.
That's line 141, Mr. Chairman?
Yes, sir.
Yes. Now, I wanted to tell you, I didn't go through the bill. I know y'all have got
Sure.
a lot of bills, but I'm glad to do so. I had circled 40 years. There were I had 2 areas where there were questions that I wanted to highlight. One was the 40 years. Again, what would be appropriate and customary? You may want to, I'm glad you mentioned that's line 141.
Has the
And
courthouse
there's one
ever
other
burned
issue.
down there?
Say again, sir?
Has the courthouse ever burned down there where you lost the records?
I suspect during the war between the states, there were a lot of courthouses burned across the state, and a lot of them might have been on the coast. I mean,
But I was
we
thinking
understand it's cumbersome to find some of this data.
I was thinking of the 40 years, since it was short of what the standard was, that
Right.
there may have been some incident that y'all know about that we don't. So that's why I was asking.
Mr. Chairman, if I may, on line 76 as well,
Yes,
I
sir.
did have, because I want to be very forthright with this, Bob. I want you to know I'm trying to solve a problem and get what I explain, and then hopefully you can help us to do that. I will tell you on line 76, we have some we had some folks that were concerned about the word "may" there, and I want to be the one to point it out. So prior to filing a proceeding under this part, we have the petitioner may present to the State Properties Commission. My understanding is that they have to do that in advance, and I am fine with that being a shall, as long as that you believe that's appropriate. But we had may in here. We've worked on this to the best of our ability. But, things like that, again, don't change the intention of providing some route to get a reasonable answer in a reasonable period of time from government on these folks that have been owning and paying taxes on land for year after year after year and now are being told it's not yours.
Okay. All right. Representative Oliver.
I apologize for these questions, but I'm totally lost.
No, you're my
I
friend.
have done quiet title actions, and that's an action against, with all these property owners around me, and we have a process where we decide who owns what. I can't figure out who you're suing for quiet title. Are you suing the state to decide if the state owns the marsh? And is
Correct.
that why the Attorney General?
Yeah, there's a presumption that the state owns all of the marsh.
Okay.
And but we know concretely they don't, because they don't own all the marsh, because there are already long certified, to use that term. There are hundreds and hundreds of Georgians who have long ago proved title to King's grants or to state
So the
grants. So a
petition
lot of our marsh is owned by private individuals.
Petition for quiet title under this special action, or existing today before this law, you sue the state of Georgia. You sue the Attorney General as the owner of the property, not somebody just because he served representing DNR. That's what's confusing me. Who
Okay,
are we suing, and under current law, and who is delaying it? Is it the judge wants to delay it, or the Attorney General doesn't want to answer?
The delays.
Who's delaying?
And I'm not beating up the Attorney General's office, but the delays, as I understand it, as I began to discover after having constituent issues, trying to understand it, trying to learn it, speaking to resource consultants, speaking to everybody, including DNR, the delays are with the Attorney General's office making a decision.
A party. The Attorney General's a party to decide whether he or she is going to claim ownership or be able to prove ownership. Is that what the Attorney General's doing in this world, in this
The
today's
process
law?
now is this goes to the Attorney General directly. The
As
Attorney
an
General's
administrative
office makes the
process,
decision
or-
on whether. Say again.
As an administrative process or as a Superior Court action?
There may need some skin edges here. Skin edges here represent. Okay. It's used generally through a special master, but
Mr. Chairman, are you going to have testimony on this to all the parties of this action can explain this to me?
I have, let's see, at
Not
least
today, probably.
3 people signed up to talk about this.
And I'm glad
Two
glad to get
opposing,
those
one
questions
favor.
and answers so we can get to the bottom of it.
Okay, I'm just
And
trying to.
I'll answer the best I can, but again,
I want somebody to tell me in a way that I can understand that who do we sue today to clear this title, and who do we sue under this bill? That's what I.
gotcha. And Mr. Chairman, it might be good to have the Attorney General's representative be here to speak to this as well.
Okay, all right,
I have met with them in the past also.
all right. Representative Kelly.
Thank you, Mr. Chairman. I was trying to flip through the code and figure out where it is that we set this process in place for review by the Attorney General to begin with. Because my question is instead of doing all this with the State Properties Commission or in this whole new process, why not just put a shot clock, if you will, on the Attorney General?
Well,
I mean, let me tell him he has to make a determination within 18 months, 6 months, 12 months, whatever we decide as a body. If the problem is there's what we consider undue delay, why not just put a shot clock on the Attorney General? Instead of taking this whole power out of his hands and putting it somewhere else. And then, because we're putting a shot clock on him in here, on the State's Property Commission.
That's correct.
Why not just do that to the Attorney General? And maybe we can't constitutionally without a constitutional amendment. Maybe we can't. I was trying to find it in the legislation.
I can't speak to that, Representative. I can tell you that again, that discussions with them led us to change it to put it with the State Properties Commission.
It kind of seems to me that if it's vested in the Attorney General through the Constitution, then we couldn't take it away from him without a constitutional amendment. So that seems to be the simplest thing to me, is to somehow just put a shot clock on the Attorney General. Just
Right.
my thoughts, Mr.
Thank
Chairman.
you. All right, Representative Reeves.
One thought, and it looks like we may be doing hearing only today, and I think that'd be good to do some follow up, like having the locals notified in addition to the Attorney General and the State Properties Commission. But one analogy is charitable trust. Charitable trust, prior to litigation, it's fairly informal. There's somebody at the Attorney General's office who's knowledgeable about that. You send in the issue. Sometimes they'll say, yeah, there's no charitable trust anywhere near that, and they'll sign something. And then you could take that to court in whatever real estate or other proceeding that you're doing about that trust asset and say, the Attorney General has said the state doesn't have any interest in this. But I would recommend take a look at the charitable trust statute, see if there could be some procedures to add into this, because they do a lot of real estate decisions on charitable trusts, and it works. It's, I don't know of things being quite as delayed and slow as you're talking about with this coastal marshland issue.
Thank you.
All right. Anything else you want to, well, hang on a second. Chairman
Just
Lever.
one comment to Representative Kelly's point. My guess would be, without knowing intimately about this process, because I've never tried to deal with title to marshland, and I expect it's its own thing, but they probably do need some kind of order at the end of the process. So just having the AG respond is helpful. It lets you move to another step, but it's probably not the end in of itself, so you probably need some kind of legal proceeding in there as well. And it may be that you need some kind of special proceeding, because you don't necessarily need a quiet title against all the world, which is sounds funny, but that's the name of the proceeding. You need a quiet title just really against the state for these purposes.
And I think we know there'll be a regular delays just with the court system in terms of getting orders and everything else. It's just, it sounds like he was saying the delay has been caused because the Attorney General's trying to make a determination. Now, I'd love to hear from them about why.
Yeah,
I mean,
yeah.
I don't know anything about this, so.
Okay. All right.
Thank you, Mr. Chairman. I'm going to let you
I don't see any other
hear from
questions.
some other folks then.
All right.
You good?
And I'm going to call up Dr. Jerry Williams at this time. Yeah. It's moved it around.
Chairman, members of the committee, thank y'all so much
Yeah,
for
pull that up. There you go.
Thank y'all so much for hearing this, and I really want to thank Representative Petrie, Representative Buddy Deloach, and the other members. And let me point out to the committee that this is bipartisan coastal support of this, and I think that's very important. I'm a seventh generation Georgian. I'm a physician from Savannah, and my family's been in Chatham County since 1788. And I live on the marsh, and it's a passion of mine. Conservation is a passion of mine. I had prepared statements, but as Representative Petrie has done a fantastic job, but y'all have asked some really good questions that I happen to know the answers to from having gone through this process. So I'm going to ditch all of my prepared statement, and I'm going to answer some of your questions because I was writing them down as quickly as I could. First of all, the quiet title action is made to the universe. It's made to the world. And we don't sue the state. You just announce to the universe through public advertising that you're declaring a need for a quiet title action on a piece of property. What happens, Mr. Chairman, and members of the committee, what happens is the State Attorney General's office does uniformly respond. And then they go into delay mode. And I have experienced this. I have a neighbor who it took 7 years for him to get his quiet title action. I'm on year 4. I'm on my 4th special master. And I've had one hearing in 4 years. And I have spent way over 6 figures dealing with this. Now, I'm a blue-collar kid who got an education. But I come from humble means. And the reason I helped bring this legislation forward is because I want to leave Georgia better than I found it. And I'm thinking about the families that Representative Petrie mentioned that don't have the resources financially or the education that I was blessed to have to be able to navigate this process. The lost records from the courthouse, Mr. Chairman, you brought that up. It's very important. I'll tell you something that's fascinating. I'm actually a Theodore Roosevelt historian, lifelong. I've worked with 2 Pulitzer Prize winners. I have a passion for history. So this kind of quiet title action is just right up my alley. The lost records actually originally occurred as they affect Crown grants on the coast in the Revolutionary War, not the war between the states. In fact, all of the plat books disappeared from the coast, all of them, except right after, for the Crown grants, except right after the Revolution, a gentleman showed back up from the Caribbean and said, hey, I was a loyalist to the king, but I want to come back now that the war's over, and I have this book. And he had one of the plat books, and he negotiated his way back into the States because of that preserved plat book. That's the only one we have. And it's down to the lower part of the coast of Georgia, the 100 miles. It's down towards the Florida border down there. So you brought up a good point, and we have had courthouse fires as well. So anyway, my point is that we have lots of grants, but we're missing some plats because of the war. The legislation is patterned after the quiet title action law, and it mimics that. So we're not putting in an alteration. We're just giving a separate path for quiet title action. Those were the questions that I saw come up, but if you have any questions of me, I'm happy to try to answer them, having gone through this process.
I have a question in that, all right, you have some sections in here that says to look back all the way to the Crown grant.
Mm-hmm.
And then what confuses me is this that I mentioned before on line 141, where you go back just 40 years
Mm-hmm.
and you make a prima facie case that the title is traced back to the grant. That confuses me. How does that work?
Well, the burden of proof of a grant to have the quiet title action, what we've seen happen when you talk about delays, the representative mentioned the delays, the Attorney General's office will say, oh, you can't read that. And then I'll go and look at it, and I've handed it to an 8th grader and said, please read that to me, and they'll read it to me. So there's this arbitrary and capricious, it can't be read. And yet I had a hearing December 2nd where the special master read it out loud to the courtroom, and he said, Representative, or Mr. Attorney General, Deputy Attorney General, or Assistant Attorney General, whoever it was, he goes, what can you not read about this? And he read it out loud to the courtroom. So there are all kinds of delays and stumbling blocks and this has been going on for years. This has been going on. There was, I have a neighbor that he went through 7 years just to get quiet title.
Right.
But this has been going on for decades.
But the current process requires you to go all the way back to the grant.
It does, and what's interesting about that is that it's putting this burden of proof where if you have the Crown grant, and like if you go to Morrow to the State Archives and you get your grant, the fact that you've got the grant and you go back 50 years, for example, as you've mentioned, and you have the grant, you have the 50-year, that really should be reasonable. Can you imagine if you're home right now, if you had to go back and trace your title back to the Crown grant, and if you didn't, the state of Georgia could take your property? Literally, that's the claim, although this is marshland, it's different than uplands. But literally, they're saying, you don't own this anymore. Now, if I don't pay taxes on my marshland, they'll take it and sell it on the courthouse steps for unpaid taxes. But when I want to restore the marshland under the watchful eye of the Coastal Resources Division of the Georgia Department of Natural Resources and the U.S. Army Corps of Engineers and get mitigation credits for doing so that are valuable, okay, then the state says, oh, you don't own that. Well, you sent me my tax bill for the last 10 years, and if I don't pay it, you'll take it away from me and sell it. But then when I want to do something conservation-based and restore meaningfully this marshland, that's the other thing I want to talk to you all about real quick. If I want to restore that marshland, meaningfully restore it, then they want to say, but you don't own that. Now, I know this is a lot to think about, but for the Judicial Committee, this is what y'all do. Y'all are the experts in this House. So I thank y'all so much for the energy you're putting into this. When you look at Google Earth now, when you look at a satellite view of the coastal marshes, these old rice plantations look like a grid. And let me explain, that's because those are the ditches and the dikes and the floodgates that were used for the rice industry. Here's the problem. After the Civil War, when all that fell into disrepair, they weren't maintained any longer. So when the water rushes into these straight canals, it rushes in at very high velocities and high volumes. And there's nothing normal about that. So it creates incredible erosion. So in fact, I was talking to Representative Deloach yesterday, and I said, you know, they don't even try to map the canal of the Geechee River from the CSX Railroad out to the ocean anymore because there's so much sand that fills it, and it shifts constantly. All that sand is coming out of those old rice canals. The problem is that those velocities and those volumes of water do not allow Mother Nature to heal herself, which is why over 250 years later, you look on Google Earth and you can still see that grid pattern, and it's only getting worse. We've gone back and compared from photographs from as early as 1947, aerial photographs, with the Soil and Water Conservation District, and we can show how those valuable marshlands are being lost. This is a conservation bill, yes, but it's also a judicial path bill that allows for an appropriate path to clear title, because that's the only way you're going to get meaningful marsh restoration, is if you can encourage the private citizens who own the marsh to restore it back to where it needs to be. If you add circuosity, ma'am, back to those straight canals, if you add circuosity back to that and slow that water flow down and decrease those volumes, Mother Nature will start healing herself. Because as that water goes around the curve and that velocity drops, sedimentation will occur. So for over 200 years, that's why you see the grid pattern when you look at an aerial view. So this is an important conservation bill, but it's also wronging a right. It's not right what the Attorney General's office does to private citizens to stand in the way of a quiet title action for land that you already own. Thank y'all so much.
Representative Reeves.
Doctor, I think you answered the question I was trying to raise with Representative Peachtree, and that's, other than tax credit and being able to put up docks, is there a private property component that would incentivize people to?
A dock would not count here, because that's not conservation.
All right.
Okay, this bill is written. If you're going to pursue this path, it can be for conservation use only, which means in perpetuity, non-revocable, that marshland goes into, and the hammocks within it, which is incredibly important maritime habitat. That goes into a non-revocable in perpetuity conservation easement. So we're talking about it can't, the property can't be used for a dock, for example, but it can be restored for mitigation credits. And mitigation credits are what you need if you're going to have to put another lane on I-95 across the Ogeechee River, or if you're going to have to do SHEP, the Savannah Harbor Expansion Project. You have to have, even if you're the state, or even if you're a public utility or the railroad, you have to have these mitigation credits, or you can't do that work. In fact, the reason SHEP took 15 years to get permitted, ladies and gentlemen of the committee, is because there were no mitigation credits available in the state of Georgia commercially, and they had to mitigate that project from within. And that's what drove the price up, and that's why it took 15 years for the Savannah Harbor Expansion Project to get permitted.
Okay, so the result of the quiet title action would not be private property and dock and things like that. It would be conservation use only.
If you pursue this path, it is for conservation use only. And Madam, you saw the provision in the bill.
Anything else that would result from the quiet title in terms of the use of that land?
No, sir.
No development?
None.
No redevelopment?
Absolutely not. Over my dead body.
Okay.
Yep. And please remember that when we included the hammocks, the uplands, thank you, Representative Peachtree, that's more protection than exists right now. The uplands right now are typically exempt. We added that because it's important maritime forest habitat.
Okay. Representative Crawford.
Yes, thank you, Chairman. Is it possible that the shift from public ownership to private ownership can mean that there's actually less conservation done in the area?
It's not public ownership. These are marshlands that are, as Representative Peachtree was talking about, they're owned by private individuals. In fact, was the announcement made yesterday that you told me about? About Green Island? Yes. Yes. Okay, so yesterday, Representative Peachtree worked very hard with the state for state funds to purchase Green Island, and if you've never been, when the transaction's done, go. It's a fabulous island. It's unbelievable. It's gorgeous. But part of that purchase that the state is buying from a private family is upland and Crown-granted marshlands. They just announced yesterday morning the state is using state dollars. What are those dollars called?
They're
GOSA funds. They're actually buying from a family in Savannah, the Lewis family. They're buying Green Island, and they're buying upland acres, which is important, coastal island maritime forest, very important conservation-wise, but they're also purchasing Crown-granted marshland acres. So there's an acknowledgement right there in the last 24 hours where the state of Georgia is actually purchasing marshlands that are privately owned. This isn't about shifting ownership from marshlands that are already owned by the state to private individuals, not at all.
Okay. Then the next follow-up question, shifting in ownership from maybe private ownership now to different private ownership, will that have an impact in conservation?
If you follow this path and you put that property into a conservation easement, it is non-revocable and in perpetuity. It cannot be reversed under any measure.
Okay.
So that protection is forever, as long as our government stands.
And Mr. Chairman, if I may, the decree to that effect.
Can you get to a microphone there? Three.
The decree, to your question, the decree is lines 144 through 152. I mean, it is on the title. That decree is made that it is concrete and in perpetuity. Yeah.
All right.
You'll see the precise language there.
Representative Kelly.
Chairman, if I may say one last thing. I know y'all got other things to do. I did want to point out to your very good question. Lines 139 through 142, remember it says evidence of the existence of a grant. Then it goes to your combined with a showing of good title for 40 years, so which of course I'm very willing to accept the will of the committee. But remember, you have to have the evidence of the grant first, combined with the history. So
Right.
Anyway, thank you, Chairman.
Thank you. Representative Kelly.
Thank you, Mr. Chairman. I'm assuming since this is a regular court filing, we could get the actual file. I just want to see what this whole thing looks like in process and what what the court file looks like from the clerk. Do you know the title of your case? Or the case style?
No, but I can get it for you. Be happy to.
That'd be great. I'd love just to kind of see procedurally, and because I'm trying to just understand if we have a problem with just quiet title actions involving marshlands. As much as I applaud your reason just to put it in conservation, I feel like that if we have a problem with just people's property rights being delayed or whatever, people need to just have a process that works. And if it's not working in this situation, it's not working in the private use situation, we need to just fix the whole thing. And so that's what I'm trying to just get to the bottom of. But thank you for getting that case styling for me.
I'll be happy to. If I may, because I didn't answer that question. It is my understanding, and I'm just a poor country brain doctor. I'm a neurologist. I'm not an attorney, and I'm not a dirt lawyer. But I want to tell you that in this process, yes, sir, that's me. Yes, sir, that's me. So my father quit high school to coon hunt, so I can claim that. I promise you. It is my understanding from and Representative Petrie has worked with the Attorney General's office on this legislation. There's been input from all directions. But what you brought up, it is my understanding that the Attorney General's office cannot be served directly. They have to represent, per the Constitution of Georgia, a department. Mm-hmm. So they suggested the State Properties Commission. That came from within. That did not come from us, because apparently it's a constitutional issue that we can't just serve them directly. I don't know that we couldn't add them to that. That seems very reasonable. But you have to serve a department. You can't just serve the Attorney General. And I think
who are we serving today?
Well, I can tell you in my case, we had to serve the governor's office.
Right.
Well, no, you're not suing the state. You're declaring it to the universe. But you provide the declaration to the world. We went above and beyond. We presented it to the governor's office by service. We also serviced I believe the State Properties Commission as well. And we also sent it to the State Attorney General's office just for good measure, because we're not trying to hide anything. We want the process to move forward promptly.
That's great. Yeah, if you could maybe get with us and get that case styling, so we can maybe find it through whatever electronic filing system, or even maybe a way for us to get in touch with your attorney who's handling this. I just need a better understanding of this whole process.
Yeah, the attorney is former State Senator William Ligon, and I'll be happy to get that for you.
Okay, thank you.
Chairman Lever.
Thank you, Mr. Chairman. I think you are, in a sense, serving the state, because you, again, my understanding of this process from, having done it once or twice and now consider myself an expert, is that you publish a notice to sort of root out the unknown claimants. And that's supposed to constructively provide notice to people that you don't know about.
And then the ones you know about, you serve. And there is a separate requirement that all neighbors have to get notice. You have to take notice to the neighbors.
We did all
In case you're trying to move your line over a little bit on Bill there, because you've been mowing it every, month for the last 17 years, because he never does a thing in his front yard or whatever. But this is not, well, I guess this is a species of that, but it seems to me like it's sort of it's sui generis because it involves, most people don't have to go back, I don't have to go back to land grants from the king when I'm running a title. It'd be tough to make money that way and never do a closing.
Yep.
But in some of these, I think you may have to, just because of the unique nature of marshlands. So again, I don't truly know that, but I think you serve the state because the state's got a claim to the marshland because it's provided one by statute.
Potential claim, yes. I can tell you
Yes,
that having traced one of my titles back to Governor Lumpkin in 1834 when he granted the marshland to James B. Schuman in 1834, most recently on December 2nd, when I finally got a hearing after 4 years, the state claimed, Governor Lumpkin didn't have the right to grant that land. Governor Lumpkin was an attorney. Governor Lumpkin was the older brother of the first Chief Justice of the Georgia Supreme Court. And we've researched the head right grant law in 1834, and he had every right to do so. But even if there were an issue during that time, the state had 5 years to respond to it and didn't. So the state is trying to ignore 189 years of private land ownership and just say, nope, we own it.
If he were any profession other than an attorney, you might have been scot-free, but unfortunately, that probably called it into question. Thank you.
All right. Thank you. Appreciate
Y'all are
your
so
testimony.
kind. Thank y'all for
Yes,
your
sir.
time. I appreciate it very much.
All right. April Lipscomb. All right, ma'am, if you would introduce yourself, who you represent, and then what you want to tell us.
Is this the one that works? Or
Be
this
on
one's
that
okay?
one.
We're good now. Okay, great. All right, thank you, Mr. Chairman, members of the committee. My name is April Lipscomb. I'm an attorney with the Southern Environmental Law Center. For those of you who may not know who we are, we're a nonprofit environmental advocacy organization and law firm, essentially. So we do a lot of work here on the Georgia coast, not here, I guess, but down on the Georgia coast, to protect our coastal marshland. So we have a lot of interest in this bill, as well as a lot of concerns about the bill. And as it's currently written, we do oppose the legislation. So let me start by just first saying that I do really appreciate the goal to conserve the marsh, because that is so important. Restoration is extremely important. So I really do appreciate, the emphasis on requiring conservation and restoration. But I don't think that creating a whole new process to really figure out who owns the marsh is the best way to go about doing that in this particular situation. So I have some comments here, but I do want to kind of step back and address some of the concerns. So Representative Oliver and Representative Kelly, I think y'all kind of hit the nail on the head with just being confused about the overall process, because I'm honestly confused too. So my understanding is that when there is a claim of ownership over marshland, you can file a quiet title action as against the world. The delays that we're hearing about are coming from the Attorney General's office, and I don't know what that step in the process is. I have looked at the Georgia Code and can't find it, so maybe it is in the Constitution. So I don't know where that is. And so to the extent that there are delays that are coming from the AG's office, I think it's important to get that question answered so that we know exactly what we're dealing with, because maybe it is just putting some, a shot clock, like you said, on what the Attorney General has to do and what their determinations are. So I think we need to answer that question before we can determine if this bill is even really needed. Now, the main reason that we oppose this bill, though, is because it really does flip the burden of proof. So as Representative Petrie said, that it's presumed that the state of Georgia actually owns the marsh. So that's the current standard. Georgia owns the marsh. And they own the marsh. The state owns the marsh unless you can prove through a valid Crown or state grant that expressly conveys ownership of the marsh that you own it. And that's in statute. That's at Code Section 52-1-2, if anybody wants to look that provision up. And the Georgia Supreme Court relatively recently, confirmed this. So there was a decision I'll point you to. It's Black versus Floyd. It's 280 Georgia 525. It's a 2006 decision. In that case, the issue was whether title marshland was owned by the state or by private individuals. In that case, the plaintiffs alleged that they owned the marshland. They could trace their property to two crown grants that were issued in 1761. The Supreme Court again recognized the longstanding rule that Georgia owns the marsh unless they could prove it. They also recognized that these types of grants, this is in the law, these crown grants and state grants, they must be strictly construed, and that no property may be conveyed by implication. And the reason for that is that the marsh is supposed to be held in trust for the public. So we have a very strong public trust doctrine for our coastal waterways. Which is important. So what that means is that the people of the state of Georgia can fish, we can boat, we can get out there and enjoy our marshland to the extent that the Coastal Marshland Protection Act allows us to do. So that's important, and that's why it's important for the state to continue holding that land in trust for the public so that all of us can continue enjoying the marsh. When that marsh is owned by private people, they can exclude the public. And that's one of our biggest concerns. So, in that case, if you're curious, the court did determine that the state owned the property because the crown grants at issue were just completely illegible. And they were not willing to give away state-owned property just because a grant existed or because there was maybe some evidence that private use of the marsh had occurred at some point. So House Bill 360 turns our existing law and Supreme Court precedent completely on its head. So rather than placing the burden of proof on private persons to prove ownership, this bill places the burden on the state. I'll turn your attention to page 6 of the bill, lines 129 through 38. And then I think going on to the next page. So that section creates a rebuttable presumption. Just subsection A, the mere existence of a grant creates a rebuttable presumption that the state has divested itself of any interest in the property. Further down, a rebuttable presumption that marshes have been manipulated by someone in the chain of title, and so on. So it's our view that we should not be creating rebuttable presumptions that private people own the marsh. Doing that violates the state's public trust doctrine. And let me take a step back, too, and tell you a little bit about my understanding of these crown grants. So a lot of these crown grants, particularly the crown grants, had conditions in them. So, you had to have members of your family be in the British military for as long as you owned the property. You had to keep the property in rice plantations for, a certain period of time. And if you did not meet those conditions, then ownership reverted back to the crown. So that means if those conditions were not met here, ownership reverts back to the state. And that's part of the reason why the law requires you to go prove and trace that title all the way back. And you also have to prove that you have met every single one of those conditions down the line. So there are a number of problems with this bill. There's one more section I'd really like to highlight too. So if you're turning to page 4, lines 76 through 89. So this does give someone the option to go to the State Properties Commission for determination first. I think this is meant to maybe replace going to the AG's office, but again, I'm not entirely sure about that process. Just some general questions. I don't know much about the State Properties Commission, but I would like to know whether they have the staff and the resources and the expertise to even conduct this kind of investigation to trace property back to Crown grants. And I'd also be curious to know if they think 180 days is enough time to do that. So when you are talking about, looking at old English handwriting and law and a bunch of these things, it's going to be tedious and time consuming. I just don't know if 180 days is enough. It might be. But my biggest concern with this section is that a certification by the commission that title has been traced, or the failure to even provide a certification, that is deemed an admission in court that the petitioner has traced title to a valid grant. So that's a giant red flag for me. I feel like, just because the commission ran out of time, that shouldn't mean that the state basically concedes any ownership interest in coastal marshland. And again, to me, that's a violation of the public trust doctrine. So for all of those reasons, I ask that you oppose House Bill 370. I'll also let y'all know, you should have letters in your inboxes from Ogeechee Riverkeeper, 100 Miles, and retired director of the Coastal Resources Division, Susan Shipman, also voicing their opposition to this bill. So I'd refer you to those as well.
All right. Representative Kelly.
I'm going to waive.
Waving. All right. Representative Reeves.
Ms. Lipscomb,
Yes, sir.
you mentioned one doctrine says there's a presumption that land is owned by the state if it's title land, and I looked at the Black case. The state of Georgia was the party in
Yes,
that
sir.
case, not the state properties, not the Attorney General. The state was, and the issue there was navigability. Is it navigable or not? And then also in that case, the court found that Crown deed was indecipherable, illegible. But I've heard a couple people mention here that the locals are taxing the land. Since we're talking about the Crown, I mean, in Georgia, the government can, on one hand, tax private property, and then on the other hand, say it's public property. Would you
Right.
agree with that?
I do agree with that. So
So-
I do. That is a problem that should be fixed.
So one thing, Representative Peachtree, I would, encourage you to consider building in this bill if the government is taxing that land, that the rebuttable presumption may flip. That the rebuttable presumption is it's private property if the land is being taxed. So, thanks.
Chairman Leverett.
Thank you, Mr. Chairman. Good afternoon, Ms. Lipscomb. How are you doing?
Good.
Good to see you again. So it is I understand one of the objections is we're shifting the burden of proof, basically. We're creating what is a burden upon the private owner to establish their ownership of marshland and creating a rebuttal presumption the other way. Right, and that's one concern you have about the bill.
Correct.
Now, it is, I would note it is rebuttable. It is a shift of burden, but it's not conclusive in any way, correct?
That is correct.
Okay, but you would still think it's better policy, I guess, for protection of the marsh and public use of a marsh to leave the presumption the way it is?
I would.
Okay,
Yes.
all right. As far as I haven't had a chance to read all the parts of the bill, but the professed intention of the gentleman on whose behalf, or one of the people on whose behalf the bill is being offered, is to encourage conservation and preservation of the marsh and encourage some, not really, I guess, mitigation measures or something like, to try to preserve it longer term and to stop and to undo man-made changes from hundreds of years ago that still today are having bad effects or impacts upon, I guess, the longevity of the marsh, as I understand it. So if some of that, supposedly is in the bill, if some of that were made clear, would your organization have less of an objection to the bill if it's clear that it has to be for that purpose and if the ownership is established, they have to in some way meet certain benchmarks or do something of that nature? Would that make the bill less objectionable to you, or do you still have fundamental problems with it?
I think we still have fundamental problems, just in light of the public trust doctrine and its importance on the Georgia coast. I think to me, what this does, it creates a pathway for people who may not actually have a valid Crown grant to take ownership, assert ownership of marsh that should actually be owned by the state. And so that's my biggest concern, is that it does create that pathway, and people who, there very well, I'm sure, are people who have valid Crown grants, and I hope that they can get that certified. But if you don't, then those people, to me, should not be able to take state-owned property and then make money off of conservation or mitigation credits that they would sell to offset destruction of other coastal marsh property or, wetlands or whatever it may be that they're trying to mitigate for.
I see. So part of your concern is they would be using the ownership of this marsh, which they may be preserving, to allow somebody else to destroy the marsh elsewhere?
That is one concern, yes.
Okay. So does, I guess the one thing that does, and I think y'all just alluded to it, it does seem a bit harsh to say, well, you've got to prove you own this thing, that you've been paying property taxes on for a long period of time.
I agree with that.
Okay. But I suppose you would resolve that conflict by just saying you can't tax it.
Yes.
Yeah, okay. Thank you.
So if somebody's been paying taxes on it for all these years, or do they get a refund?
That is a question for y'all to, I think, to decide. I'm just an environmental lawyer. The tax laws. I'm going to do what y'all do. I'm not a dirt lawyer.
Okay. All right. We got one question. Representative Silcox.
So my question is the fact that they also included the uplands in this, in addition just to the shore. To me, arguably, this would, certainly if someone puts a conservation easement on this in perpetuity, this would conserve the land better, perhaps.
Well, you know, so the uplands is an interesting piece. So the uplands, I think, in the bill are defined as marsh hammocks or islands.
Right.
So we're not talking about going up on the, mainland. So, yes, having a conservation easement on that property would, it depends on what the conservation easement says, but if it does prohibit any kind of development, then yes, that would be strong. But, we also do have the Coastal Marshlands Protection Act that does prohibit a lot of that activity already.
Okay. But by definition, a conservation easement, my understanding is you can't put any structure on that property going forward.
That's
in perpetuity.
Well, if that's what the conservation easement says, then yes.
And that's broader than the existing law, correct?
Than the Coastal Marshlands Protection Act?
Correct.
Yes, it would. Yes, so the Coastal Marshlands Protection Act would allow potentially some types of structures or docks or things if people were able to get a permit and show that they could do that.
So again, arguably, this would protect the land more than existing law.
I don't think necessarily it would.
Okay.
Again, if the state truly does own the marsh, then the state can go in and do all this restoration activity. There are, I think, better ways of encouraging people to conserve the marsh and restore the marsh than by, again, just changing this whole process of figuring out who owns the property.
But I guess I would like to add that I think that if the mitigation credits can be awarded to private landowners once they've done these conservation easements, then arguably the ability to use private funds and not just state funds to restore those marshlands in a more enhanced manner is a good alternative.
Yeah, and I don't disagree with that. So if people do own the marsh and they do restoration activities on the marsh, they put it in conservation, they sell mitigation credits, that I am fine with that. I think that's fantastic. That's a great use of their time and energy. What I am concerned about is this new procedure, this new equitable procedure that is being proposed to figure out who actually owns the marsh, because I do think it could lead to a path where people who don't technically own the marsh get ownership.
Do you know what the style of the case would be, to Representative Kelly's earlier question? Do you know how the case would be styled? I'm just curious myself.
I mean, typically,
is it in Ray? I mean,
it's so. I believe the gentleman here's. I think I actually have copies of it, so I can find that for you. But it's generally a person is suing the property, and then kind of the world to retain ownership over it in a typical quiet title action.
Okay, thank you.
Mm-hmm.
Hang on.
Thank you, Mr. Chairman. I just want to speak to one thing the lady just spoke to be clear. So if I have a King's grant and I go through the process without this route, in the customary route today, and I prove my title, as many have done, okay, already, and many others haven't but own land so if I do that, the uplands are not encumbered in any way. And so I could, let's say I've got 500 acres of marsh and 20 acres of uplands on the mainland, all part of this grant. I can do anything I want with those 20 acres. I can build a hotel on it. You can't do any of that with this. Every acre, to include the uplands, would be encumbered, and they wouldn't be otherwise. I just want to make that very clear.
All right. Representative Kelly.
Thank you, Mr. Chairman. And Chair Lady Silcox, Chairman Petrie gave me former Senator Liggins' contact information, so I'm going to reach out to him and hopefully have an opportunity for him to give me some information about the style of the case there too. We heard a little bit ago from Chairman Petrie about Green Island being bought. That's certainly a conservation effort that the state's invested in. think that's exciting for all of us. What other efforts is the state or the local, the local government? I'm assuming it have to be state. What other efforts are the state doing to help conserve and protect the marshlands?
Ooh, that is a broad question, and I don't feel like I'm personally qualified to answer that. I would probably refer you to DNR or Coastal Resources Division. They would be able to answer that in a lot more detail than I can.
Okay, thank you. I'm just trying to figure out if we have an avenue for it to be protected, through a private process, are we being good stewards as a state, or would we be doing it better than a private? So that's why I was trying to get the comparison on what we're doing now versus what could the potential.
Right.
Thank you.
Mm-hmm.
Chairman Lever.
Thank you, Mr. Chairman. Just I want to follow up with you. You had mentioned the public trust doctrine. Is that established by statute, or is that a common law doctrine, or?
It's both. So it actually started Old English law. So back when we were a colony, the crown owned all the titles, all the coastland in England in trust for the public. And so that's where that came from. Okay. But it is in our code, so it's OCGA 52-1-2, I believe, if I have that correct.
Okay, I think that's too many dashes, but
52.
Oh, 52-1-2. I got you. So, and is that part of the coastal? There's some references even here. I'm assuming it's a state law, the Coastal Marshlands Protection Act. That's state, not federal.
It's state law, yes, sir.
Okay.
The Title 52 deals with waters of the state, ports, that type of thing.
Okay.
The Coastal Marshlands Protection Act is in a different code section. That's in Title 12.
Okay, all right, great. All right, thank you very much. Thank you, Mr. Chairman.
All right, ma'am.
Okay.
Thank you.
Thank you
That's
all.
all the questions. And Kevin Lang.
Thank you, Chairman.
Yes, sir.
I'm not an environmental lawyer or a dirt lawyer, but I am a lawyer. I'm a corporate law, M&A lawyer, corporate lawyer. But I do spend a lot of time working on coastal conservation projects. Most of my pro bono time over the course of the last decade has been spent on coastal conservation efforts. I want to focus my comments today on the sea change that House Bill 370 will affect on the current state of Georgia law and public policy on ownership of coastal marshlands. The state of Georgia currently owns almost all of our coastal marshlands as successor in interest to the King of England. The state holds these coastal marshlands in trust for the use and benefit of all Georgians under the public trust doctrine. This, coupled with protections afforded by the Marshlands Protection Act, have resulted in over 368,000 acres of marsh being protected and left in their natural state. State ownership of marshlands is presumed unless a private owner can demonstrate his or her predecessors in title received a valid Crown grant from the King of England and that the grant has been carried forward through every subsequent conveyance of the property. The current process involves a rigorous examination of title to the property that is administered by the Attorney General's office by attorneys who have expertise analyzing complex titles. These title examinations are extremely complex. I recently had good reason to examine the title of property that Camden County Commissioners proposed to develop into a commercial spaceport. The county's consultants had represented to the FAA that Union Carbide Corporation had a valid Crown grant to the coastal marshlands surrounding the launch pad, and that it would be okay for them to use it as what the FAA describes as a debris dispersion zone for exploding rockets. My research took me to the Hargret Rare Book and Manuscript Library at the University of Georgia to find the original deed out of the King of England, and then to the state archives that Dr. Williams mentioned in Morrow to pull the corresponding plat. Once I completed the research project, it was clear that the Crown grant for the property explicitly excluded the marshlands surrounding the upland acreage, so title to the marshlands never left the King. No Crown grant. My point here is that these titles are very complex, and the current process involves a rigorous examination for good reason. It is important to get it right. Justice George Carley, who I miss dearly, authored a unanimous opinion of the Georgia Supreme Court in 2006 involving a private landowner's claim of ownership of the marshes surrounding his Richmond Hill property. Justice Carley noted in his decision that Crown grants must contain, quote, explicit conveyance, and any ambiguity must be, quote, strictly construed against the party attempting to defeat, to defeat the state's title. The decision by the Georgia Supreme Court describes the current law in our state for establishing Crown grants, and House Bill 370 is diametrically opposed to this decision and the public policy that underpins it. The fundamental problem with House Bill 370 is that it shifts the burden of establishing Crown grants from the property owner to the state. Under the current draft of House Bill 370, any property owner who wants to try and defeat the state's title to marshlands has the ability to file a title abstract with the State Properties Commission. If the State Properties Commission fails to issue a certification of title within 180 days, their failure to respond will be deemed an admission that the property owner has traced his title to a valid crown grant. If the State Properties Commission disagrees with the property owner within the 180-day period, the property owner may then file an action in rem in the Superior Court to try to obtain their desired outcome. If the State Property Commission disagrees with the property owner and the property owner subsequently convinces a local Superior Court judge that the State Properties Commission was wrong, the property owner may actually recover fees in bringing the local action from the state, which is pretty significant provision. Another fundamental flaw with House Bill 370 is that it allows a property owner who has already been told they are wrong by the State Properties Commission to compel a Superior Court to appoint a special master to decide the case. This special master's only qualifications are that he or she is a duly licensed real estate lawyer in the state of Georgia. It is easy to see House Bill 370 creating a cottage industry among title examiners and attorneys on the coast, creating a conveyor belt for delivering fee title to coastal marshlands. And I believe that's exactly what this bill is designed to do. Members of the committee, it should be difficult to defeat the state's title to coastal marshlands. The current process is rigorous for good reason. I would encourage you not to advance this bill and to leave the current, state of the law on this important subject intact. For you lawyers on the committee, I'm confident that the ghost of Justice George Carley will haunt you forever if you support this effort to shortcut a process that is designed to get it right. And I appreciate your time.
All right. Representative Reeves.
How do you address the issue that it sounds like there are many property owners who are getting taxed on this allegedly
It's a
public
county,
land?
It's true, and it's a county issue, not a state issue. I mean, the issue is that the counties probably should not be taxing the marshlands. But if you look on QPublic and look up coastal properties, in almost all cases, counties and the coast, they include the coastal. They go right to the water line on the boundaries. That doesn't change the fact that those marshes are, for the most part, owned by the state. The counties probably shouldn't be taxing coastal marshlands.
Well, I mean, that affects education funding and many other things, and it does impact the state.
Yes, sir.
You can't say it's a local issue when it's property taxes.
That's true. That's true. However, I would say this: the value, most counties, when they assign value to marshland for tax purposes, it's exceedingly low. It's very low. The same as a part of your property that's in a floodplain in the uplands. You know, they put an extremely low value on it. I don't disagree with the fundamental issue that the counties shouldn't be including it in fee simple title like the uplands acreage. I have no disagreement there.
It sounds like you have a lot of amendments to the bill, but one amendment of adding the locals, if they have a basis to be taxing a property owner for allegedly private property, don't you think that'd be a good change to the bill?
Representative Reeves, I think the bigger issue is not the ad valorem tax issue. I think the bigger issue is that this bill affects an absolute fundamental change in the public trust doctrine and the general presumption that we have that the state owns these marshlands. One of the reasons Georgia has 368,000 acres of marshland is because of two things: the public trust doctrine, and secondly, the Marshland Protection Act, which was passed by both this body and the Senate in 1970. The result of that is that Georgia, unlike a lot of our neighboring states, we have the benefit of having protected almost all of our marshes. And if you go to the coast, which I do as often as I can, and see the beauty of our coastal marshlands and see all the people enjoying them, the reason for that is because they're owned by the state. April Lipscomb made a great point in that there's a fundamental shift occurs when someone establishes a Crown grant. From that point forward, you can exclude someone from your from that property. I mean, it's yours. It's no longer the state's. If a tidal creek runs off of the Cumberland River, as it does where I go to Little Cumberland Island, that creek that goes through the marsh now is private property, and you can put up you can tell people you can't get off and walk in this marsh. It's because it's privately owned. That's not the way that our marshlands work now in Georgia. They're all state owned.
Well, I think that being subject to property taxation is the biggest burden a private property owner could have. So, if they're getting taxed, they ought to be able to exclude people from their property. And so, I think the public trust doctrine needs to be reconciled with this local taxation of the property. That's a serious issue.
Yeah, what I would say this, Representative Reeves. I think for me, what brought me to Atlanta today to testify, it's the fundamental concern of just getting it right, getting title right. And right now the process is rigorous, and it does involve a lot of time with the AG's office. But the representatives at the AG's office that are doing this now, they're experts in this area. They understand what these instruments look like. A lot of times they're illegible. A lot of times there are gaps sometimes in the title. But the people at the state AG's office that do this are trained to do it. There are people who are unable to complete the chain of title. There are people who have, like the Black case that we mentioned, the documents existed, they just couldn't be read. It is difficult, but it's difficult for a good reason. In that this is a private landowner trying to defeat the state's title, and it should be difficult to do that.
Chairman Leverett.
Thank you, Mr. Chairman. Thank you for driving up here. I know it's a long way. As I read the bill, I'm not sure if it specifies this elsewhere, but the decree that you get says the uses of the property, the coastal marshland subject decree, are restricted to use for conservation purposes, and that's defined in the Act. Mm-hmm. So I think I know your answer, but it would seem to me that to Representative Kelly's point, we've got an existing presumption that favors state ownership. And I think you would say that's the better policy, because that way we all can enjoy the marsh, not just a select few. And I know, frankly, you were a bit dismissive of this. I think if it were your tax bill, you wouldn't be quite so dismissive of it. But even if it was $25 or $50 a year, I would be a little upset if I was being told I had to go through what seems to me to be a pretty rigorous and lengthy and expensive process to establish ownership of something I'm already paying taxes on. So I do think it's an issue for us, and I think it's something obviously a lot of us are going to be sensitive to. But to Representative Kelly's point, maybe saying, well, we'll let you establish your ownership, but we're going to limit what you do with it to conservation might be a better policy in terms of conservation and preservation of the marsh than what we currently have. I wanted you to comment on that.
Yeah, well, I'd start from the premise that in order to do anything to the marsh other than leaving it in its natural state, you're going to have to first establish that you own it, right, through a King's grant. That process is difficult now for a reason, in that there is a presumption that the state owns it under the public trust doctrine. If you're able to go through that process and establish that you own it, then I think that you should have a Crown grant and it should be yours in fee title. But the property tax issue, I'll give you an example of Little Cumberland Island is surrounded, where the community I'm involved in, surrounded by thousands of acres of marshland. We have a Crown grant. We have never gone through the process with the AG's office to establish a Crown grant. We pay tax on that property. So to your point, I do pay tax on coastal marshland. We do pay tax on that coast. However, we respect our relationship that we have with DNR. We trust they're good stewards of that resource. And that's the reason that we've never gone through that process, is because we have an excellent relationship with DNR and we appreciate the work they do. And we just don't see the need to take that step.
Well, and thank you. And if you don't mind paying that tax bill, I got one for some great property on Tustin Street in Overton I'd like to send you there too. But I guess my feeling is, maybe you've said there is a longstanding policy, and I'm sensitive to that, because I do believe we ought not to just change policies willy-nilly. We need to do it deliberately and with thought. But I'm just wondering if this might not be a time to change policy, because it sounds to me like we've set up a set of presumptions and a system which, by your own admission, is almost impossible sometimes for a private landowner to satisfy. It's the deck is kind of stacked against them by design, and I'm just wondering if it might not be time to change that, but say, sure, if you want to establish ownership, we're going to make it a little less difficult for you, but we're going to require you to utilize this property in a way that we're kind of encouraging it be used when the state owns it anyway.
Yeah, I would say two things. One is just it is difficult, okay, to establish, but it's not. If you have a Crown grant and your instruments exist, it's not impossible. And there are title examiners, Mr. Keatle, who was referred to earlier. There are certain people who do nothing but this on the coast. It's not impossible if the instruments exist.
Yeah, and I don't want to take their livelihood away. So
no, understood. I understood. And so it can be done, first of all, and secondly, I don't see anything in this bill that requires a conservation easement. I see a requirement for conservation use, which is different, right? So those are two different things. If what's implied in the bill is that the property should be required to be put in permanent, perpetual conservation easement. I don't see that. I don't see that in the four corners of this bill as drafted. I would say this to the argument that, that this is not a conservation bill in my view. This is a bill about being able to establish conservation credits, much like the activity we've had in Georgia with conservation easements and all that goes on. I'm sure that you guys on the Judiciary Committee probably know what's going on with those deals at the moment. I think this is, in my view, this bill is more about creating a system whereby someone can establish fee title to marsh and then use it to generate credits, which equals money.
Well, and I would say I have just reviewed it while I'm sitting here, so I can't swear that. But I would say in lines 148 to 150, part of the decree says it's restricted to use for conservation purposes, and that is defined in the Act in a way that seems to me pretty beneficially to a conservation end. So I think, though, the other point, to be fair, is Ms. Lipscomb's point is, yes, but they can exclude others from enjoyment of the marsh too.
That's the essence of fee simple ownership.
Yeah,
Yes, correct.
So I mean, that I think does weigh the other way to your point as well. But thank you anyway for engaging in this discussion with me.
Representative Kelly.
Thank you, Mr. Chairman. I thought when I saw you sitting back there, I recognized you, and then when you reminded us of our conversation with the spaceport years ago, I started to have some PTSD.
Me too. Me too. Me too.
Some of it felt just like this, Mr. Chairman. I'll be honest. So I haven't gotten to a point where I feel like I understand the issue enough to have made a decision on where the presumption should be. I haven't got there in my mind yet. I haven't got to the point through the debate whether my initial thoughts are, and I understand litigation is complex, processes are hard, and the hard things are worth it a lot of times. But it doesn't seem reasonable to me the delays we've heard about. Can you help me understand that some, or could you tell me if we're able to do what I kind of suggested at the beginning, figure out where the Attorney General has this authority and just put a shot clock on them? Yep. What should the shot clock be, and then help me explain the why the delays in your mind may be justified?
Yeah, it's the length, I think, is largely to do with the complexity of the titles. They're incredibly complex, and a lot of times they have conditions in them, which you have to go back and look and see if those conditions were carried through title. So it's not just a simple exercise of Crown grant, owner, present owner, right? You've got to go through and you've got to actually read the instruments from thoroughly and determine if those conditions have been satisfied. That's the reason that it takes so long, I think. Now, I think the better path, in my view, on this issue is that maybe an urging resolution to have the AG's office set up a new system where they do this quicker. They're on a prescribed time period to respond when they get a submittal. I wouldn't throw out. I don't think it's necessary to throw out the current process because we have individuals that are experiencing delays. I think that the current process is that should be. We want the state's legal counsel. If the state's going to lose title to its property, we want the state's legal counsel to be involved in that analysis, that title analysis. I think that's very, very important. I do think that the main objection I've heard to the current process is the length of time it takes, and I think that maybe what would be appropriate there is an urging resolution to and I've recommended to Chairman Petrie. I mean, maybe the appropriate action is an urging resolution to the AG's office to set up a better process and respond to these petitions quicker. But I don't think pulling it out. I don't think taking it out of the AG's office and moving it to the State Properties Commission is the correct avenue.
Representative Oliver.
I'm not dismissive of the tax issue. That's a real issue that we could resolve in some way. I'm also very mindful that Georgia has done a better job of protecting its marshland and its coasts than any other state on the East Coast.
Yes, ma'am.
Part of that's Jimmy Carter, and part of that is the Coastal Act of 1970. And I am very concerned that I'm asked to make some decisions about things I do not understand, except for the principles of the taxation is important, and Georgia's done a better job than any other state on the East Coast. This is a really this is a complex area. Why the property commissioner wouldn't take more time to figure out this complexity or less time than the attorney general is lost on me. It's going to go to the same lawyers. Mr. Chairman, this is an area that we really need a study on to educate us policymakers who don't live on the coast but who love the coast and who are respectful of issues of taxation, and the fact that the state owns this marshland that some property owners are disputing.
I would thank you. I agree with you, Representative Oliver. Also, I would encourage this committee to reach out and get the opinion of the Coastal Resources Division. You've got people whose job with DNR is to conserve and take care of this resource. Get their opinion and see what they think about this. Okay. Secondly, I think I'd get the AG's office involved. I mean, if I were considering this bill, if I were you guys, I would want to hear from both the AG's office and I would want to hear from DNR about their thoughts on this change. Because the main reason I came today is I wanted to just emphasize this is a sea change in the way that these titles are handled. This is a completely reversal of the current situation, and it's a very important issue for all Georgians.
Representative Reeves.
Before you drive back to Savannah, I just want to say thanks for doing pro bono work. This is an area that needs a lot more pro bono lawyers, so good luck recruiting them. One thought to think about or to take back: every year when those tax bills go out, the choice is taxability or fair market value, uniformity, or taxability / exempt. One thought is, if you have property owners who don't claim that marshland, if they own 10 acres and 2 acres of it is in that marshland, check that box about exempt or non-taxable, turn that into the county with the plat and say, that's public land, that's not my land. So that's one thought on pro bono work for the people who don't claim it.
Right.
But for the people who do claim it and they're getting taxed, I think that's an area that needs some legislation.
Thank you, Rosa. And I'm from Athens, by the way. I didn't want to correct the record. Thank you. Yeah, thank you. Yeah.
All right.
Yes. Yeah. Thank you, guys.
Right.
Any further questions?
No, I just want to say I like the idea of a study committee. I want to chair it and go down to the coast and check all this out.
We'd be glad to host you, Chairman. Be more than happy to host you.
Okay, this is hearing only. We're not going to take up any vote at this time. I think we need to look at this important issue a little longer and try and figure that out.
Appreciate you guys giving me some time.
All right, now Chairman Leverett stepped out. Before we finish on this, Chairman Petrie, you have anything else you want to add?
No, Mr. Chairman, I just want to thank you. You got me here. I just want to thank you for your time and listen. This is what I ask. I asked for this good due diligence. You've given that. I thank you. There have been some, the notion that if someone establishes a King's Grant when it's entirely in conservation easement, people aren't going to be able to traverse across it is absurd, as you just heard. That's nonsensical. So there were some things that I heard that I don't have time to go into all of them, but I think everyone here understands the intention, and if there is a way to find a good way to do that, I'd love to do that in the interest of fairness to the people we represent.
Well, thank you for bringing this.
Mr. Chairman.
We've
Y'all
had
been
an
most
interesting
kind.
conversation.
Appreciate all of you.
So, all right. Let's see. Did Leverett leave? Yeah. Well, he's left all his stuff there.
He's out in the hallway. Thank you. I was wondering how.
Do y'all need a break? A short break? I got it. I'm sorry? No, I'm fine. I got a judge's bladder, so I'm good. All right. Yeah, let's do 404. We'll go ahead and get started.
What's up, folks? I know you're already tired. So if you fall asleep and get to ask some questions, it's all right with me.
You're going to be quick, right?
All I know is quick, baby. I look a little chubby, but I'm like Warren Sapp. I got a first step pretty quick. Which one we working on first there?
We're gonna do 404. I've got LC 500534S. Is that what you're looking at?
That's what I'm looking at. Everybody looking at it? Let me get my notes to you. Thank God for phones. All right, thank you, Chairman. Am I live?
You are.
All right, thank you so much. Got before you House Bill 404, aka Safe at Home Act. I'll go through this legislation pretty quick about what it does, and then obviously you will comb through this like with a fine tooth comb, I do believe. But for the first time in state law, this bill will require rental properties to be fit for human habitation, a term that is left unidentified to leave judicial discretion. For the first time in state law, this will place a cap on security deposits at no more than 3 months' rent, including deposits for pet fees, etc. For the first time in state law, this will mandate that landlords provide tenants with a 3-day cure period after a missed payment prior to the beginning of the eviction process. For the first time in state law, there will be an expedited eviction process for tenants who are charged or convicted for certain criminal offenses. Crimes against a person, sexual offenses, serious violent felonies, or crimes that threaten the safety of other residents. And finally, it prevents the landlord from turning off the air conditioning during the eviction process. So obviously there's been a lot of talk about tenants' rights bills throughout the chamber, both sides of the aisle. What this bill seeks to do is address some of the remedies so that we're able to address bad tenants and bad landlords in a way that people feel safe at home, they're able to enjoy their property, and without that, I'll be glad to go through each section of the bill, but that's basically what it does. You've been here all day, so I'm not going to go through each section. If you want to, as you're looking through it, if you want to ask
If you want to
questions.
just kind of hit the highlights of each section.
Yeah, that's fine. Absolutely.
All right.
All right, so here we go. Section 2, the first part, 17 through 19. That's the piece that we just discussed about being fit for human habitation. The purpose of this part is to say that, look, when I rent my property, if the air condition is working, as a landlord, I have to make sure that landlord stays working. So it's it has to be habitable or livable. We're going to use livable because I have a hard time with that word. So the property has to be livable when I rent the property, and it has to remain livable throughout my lease. Section 4 goes over the security deposit piece that we touched on that talks about the 3 months cap. Now, obviously, most players in this industry do not have a 3 month. Most people use a 1 month rent cap for a deposit, but we felt this was necessary because there are options out there for churches, et cetera, that are willing to pay a little bit more on the front side for the security deposits if for landlords to take tenants that are a little more challenging. Section 4. I'm sorry, the same one. Sorry. Section 5. This is the criminal activity part, and I look forward to conversation in this committee on this section. I know it's a very challenging section. I think the point is landlords and tenants want to figure out a way to get rid of bad actors so that, one, people feel safe at their house. If you've got somebody next door that's doing stuff criminally, there's not a lot right now that landlords can do to get rid of them. And so obviously this language needs to be perfected, but I think we need to discuss it, and we need to figure out a way. When you have two parties on the side of an argument and both agree that we need to figure out a way to do it, I think it's our job to help figure out and facilitate that conversation.
Any definition of criminal activity that you're talking about? Because, I'm thinking ordinances that a city or county might have, that noise, that kind of thing. If you're in violation of that, have you committed criminal activity that would cost you your apartment or whatever you're
So I don't have the code section in front of me, but if you could pull up 44-7-53, that'd be great. Mm-hmm. And then as you
Chairman, line 83.
you keep coming. Yeah, we're not to that section. It's 83 through 100 as you get on down through there as well.
Got it. All right.
Okay.
Thank you.
Sorry. I apologize. And then you've got the right to cure piece is 52. Or I'm sorry, yeah, 52 through 61. That gives you a 3-day notice. And then obviously the piece on at 64, 65 details having to deliver that that it has to be tacked to the door. So that piece was important for a lot of people to make sure it wasn't just verbal. And then you go into section 6, and this is the criminal part we're talking about. I'm sorry. 83 through 100 if you want to look through that. But basically the point is to give landlords an expedited opportunity to get rid of tenants that are doing criminal activity, to make sure that they're able to address them in a more rapid fashion so they can actually make sure that people next door are safe. And so as you look through the process, it gives you 14 days to reply. At that point, you have a hearing, and then after the hearing, obviously depending on what the judge says, you'll have another 14 days for it to be executed. So it basically gives you an opportunity, basically within a month period, to get rid of a bad actor or actress, I guess, if we're going to be correct here. And then going down into section 7, it continues to address this part and making sure that the law enforcement, et cetera, knows that they're able to, that they have 14 days to take care of it. I know there's going to be a ton of people talk on this bill, but I will be glad to answer any questions.
All right.
And obviously not an expert on this issue. Heart's in the right place as a both a landlord and a lifelong tenant in various forms and fashion. So.
All right. Representative Hong.
Thank you, Mr. Chair. Thank you, Chairman. Just a few quick questions.
Sure,
Page 4, so I think this is touching upon Chairman's question. So line 83, you started defining criminal activity. So on line 84, it says a charge or conviction for a crime. So are you referring to any type of arrest for any type of crime?
I don't think so. I think if you further on, it says that threatens the health, safety, or welfare of the other restaurants, residents, landlords, or landlord agents.
Okay, and I'm sorry, and I should.
It's been a long day.
Yes. My question is, would it be also for an arrest? Is it an arrest before even any type of conviction?
Yep,
is what you're looking at?
That's right. Mm-hmm. And I think that the challenge is, I understand the challenge there. As someone who hires people with second chances all the time, I understand that's a challenge. But also knowing the length of time that it takes for an actual conviction kind of pretty much guts the whole purpose of this legislation on this point. So I definitely will defer to your expertise, but I think it's important to realize we have two parties that are in agreement that are never in agreement. And we, as a body, need to figure out a solution to address it. And I hope that with the knowledge of this committee, we can come up with something that we can all live with.
Thank you. And just a second question is page 5.
Mm-hmm.
And starting with line 98. So essentially that section 3, starting with line 93, has to do with if there's no answer by the tenant. Starting with line 98, section 4 is if there was an answer. Why? And then if you go down to line 109, why don't we put that language up at the same?
Let council. We
okay.
Can feel free to fix it.
Yeah.
Group it together. Do your deal.
Yeah. I was wondering why there was a separate section that we had to amend, since we're basically essentially saying if there was an answer, if there was no answer, then 14 days, and then 14 days to execute the writ. And then if there is an answer, 14 days, and then 14 days for
I believe that section 7 deals with the delivery of that writ. That's why it's separate. But don't make me perfect.
As well as section 3 as well. So
Okay.
it's just if somebody was reading the code, that's all.
Yeah, I understand.
Saying.
I mean, to me, not a lawyer, section 6 deals with the court's activity, and then section 7 is more the marshals and the cops. But we'll obviously have somebody talk about that, I'm sure.
Representative Reeves.
Representative Carpenter, thanks for bringing this bill. One thing Representative Hong and I and the other 21 House members in Gwinnett County have been working on is homestead property tax relief. And one statistic that jumped out at us as we looked at that in the second biggest county in the state is since 2019, the number of homeowners in Gwinnett County, despite the fact new houses have been built, has gone down from 128,000 to 123,000 since 2019. So you got about 5,000 fewer homeowners in Gwinnett County. People have moved and rented out their old house, or they've sold their house to somebody who's a landlord. So in Gwinnett County, we've got a lot more landlords and tenants over the last few years. So this bill becomes all the more important to me and folks in my district. Two questions. Number one, the eviction execution process is really dysfunctional following COVID. If you get an eviction or writ of possession today, it takes months to get that carried out. Is anything in this bill done to address that? And then secondly, I know this is a substitute. I've got LC 50534S. You've been working hard on this, but I know some of this is newer than others. What's the newest part of this bill that may not have been? Is there anything in here that is a day or two old, or people might, not fully?
No, I don't think so. It's been part of a lot of the parties that have been part of the conversation. It's been tightening up some of that language. It does not address the ability to speed up the process that's happening in Gwinnett. Frankly, seeing all over the metro area. You get outside the metro, and a lot of these folks are really processing this stuff in a much better fashion, for sure. I will say that Whitfield County, much like Gwinnett, is a heavy renters market with the carpet mills, et cetera. There's a lot. I would say I have probably one of the lowest property ownership rates in the state of Georgia, so I understand what you're dealing with. The dynamic is interesting for sure, but this bill does not address the issue that you're talking about, unfortunately.
Well, appreciate the work you've done on this. Look forward to hearing from the other witnesses.
Representative Oliver.
There are so many opportunities that we have for a good discussion on these issues, and there's absolutely no doubt that tenants are living in circumstances that are unlivable and not habitable. I don't think that's disputed, and we're not dealing with that in any kind of effective way, in my opinion.
Okay.
And we're attempting to in this bill.
Mm-hmm.
On line 19, you refer to the premises as not fit for human habitation. What is the policy reason for not defining that with more specificity?
Okay, so
because most states do.
Yeah, right, sure, I understand. So I've really been mulling that conversation because obviously we've had it. I've had it with a couple of others as well, and I was excited to be in front of the judge today because that's really the point, right? Is to allow the judges to make that decision. I think if we narrowly tailor that language, we're not going to catch everything, and I would hope that our judges would be able to discern what they feel is habitational, livable. Sorry, wrong word. And I would ask the judge that question: is that something that, reading this language as you see it, as a judge sitting up there making that decision, would you, do you appreciate the ability to make that decision, or?
Well, what you're ultimately asking for is the appellate courts to set out what is fit for human habitation. So,
okay,
it would, temporarily while I make a decision, that would stand as the law until it gets up into the appellate courts, and then they disagree with me. They'll set it out or reverse it back, and then I've got to try again. Somewhere along the way, the courts will be setting that down as they'll define that definition.
Okay.
We have so much other opportunities in other states that have chosen the majority to define it that we could get some real guidance, so we don't have to wait 1, 2, 20 years for this definition. So I'm really thinking that the policy reason for defining it is important in my mind. The practicality of your timetables, given the dysfunction. I used to be an eviction judge during my earlier year, and from those earlier, simpler times to now, getting somebody really evicted is impossible in the COVID world, post-COVID, where you have to pay for it, you have to schedule it, all that martial stuff is really a problem, which brings us back to a couple of other practical issues. Why do you say that a failure of a tenant to pay utilities to Georgia Power would be the right of a landlord to?
Sure. So that would be stuff that was owed to the landlord. So if let's say I rented you my property and I included utilities in that lease and I paid them and then you paid me, or I included them for $1,200, you can rent my place with utilities. So that basically encompasses that. It doesn't say anything about paying the utilities to Georgia Power, so it'd be negotiated in the lease, obviously.
I think it's
there was
confusing.
Sure.
So that might need to be clarification.
Mhm.
If I may have one more, Mr. Chairman. X percentage of tenants are there with the standard lease that sometimes says 1 month security deposit, one says maybe first and third month. What I'm concerned about is that everybody now is going to go to the form lease to ask for 3 months security deposit. And that's going to make another gazillion people unable to be housed. I think you're raising the standard and you're not minimizing the standard by putting 3 months in there. That's my fear.
Okay. Yeah, fair. I mean, I think in practice most people do one, right? I mean, where I'm at in a heavy renters district, it's 1 month. I mean, you can't squeeze blood out of a turnip, right?
Well,
I mean,
this
if
is
you got
gonna
$700, you got $700.
This is going to squeeze that blood and make them unhousable.
Yeah.
Because if everybody goes to 3 months for a security deposit in their form lease, that's
Oh,
a
yeah,
way,
no, I don't
that's a way
disagree with you.
to get rid of bad tenants very efficiently. And if we say as a matter of law, you got to have $6,000 up front to rent this apartment, which is what they cost in Decatur, you've eliminated the person who can't pay rent.
Yeah, I mean, it is a cap, not a floor.
Representative Hong?
Thank you, Mr. Chair. And I'll preface this. I do landlord-tenant work, and
Yeah,
I've
well, then
represented.
come here over here. Let's switch
and
sides, girl.
I've actually represented both sides, so I'm just kind of, and I may be looking into it way more than I should. And I'll just kind of point as far as defining human habitation, and there's been some language that was proposed, and it would, for example, if a tenant, if there's any type of citations from the county for trash or something like that, and sometimes that may not be necessarily because of the landlord, it may be because of the tenant, and sometimes the landlords their hands are tied because they can't go in the property or they can't go on the property, and so it does, I think it does make it difficult when we kind of narrow that down. But on that point, so is there, and I'm kind of looking at lines 17, 18, 19,
Sure.
When we were talking about human habitation. So I'm assuming that, and I would assume reading this is regarding what the landlord's duties are, but let's say the property is not habitable and it's not the fault of the landlord, it's the fault of the tenant, and landlord's just not able to go on the property to make it habitable, and the tenant's just going to complain about it. Is there anything in here that you think is going to landlord would have an issue with?
Yeah, I mean, obviously, it doesn't touch on that side of the equation. I feel certain that's occurring. This language does not touch that issue. It's really making sure we're addressing the landlord piece to address it, and it doesn't talk about the renters who's at fault. It's just saying make sure that we keep it livable at the end of the day. No. This is your world. You better look into it. If it's fried chicken, I got you, girl. But no, this is your world. And I think that's a fair argument, right? We vilify the landlords all the time. And I think both, and Representative Oliver also discussed the eviction process, that, almost landlords are kind of held captive by the slow of the process to not get rid of bad tenants. And so that's kind of what this bill does, right? We're trying to move the needle and address bad issues on both sides. And I think that's important to recognize that not all landlords are bad. Not all tenants are good. This is a balance, and it's not perfect, but obviously it's a work in progress.
Representative Kelly.
Thank you, Mr. Chairman. As I'm sitting over here having a bite or two of popcorn, you're mentioning fried chicken. I wish you did have us right now with that. But I just want to tell you thank you for bringing this legislation. We've certainly seen bad actors from the landlord part of the equation, and I think there's some very much common sense things that we can do to help crack down on those bad actors. And looking through here, I see that we make clear that it has to be fit for human habitation. Is there a guard, or are there any restrictions right now on how long of a security deposit can be required? Is that there today?
That's not there today.
So that's a great new protection for potential tenants.
Yep.
And then it looks like, just help me make sure I understand, going through lines 52 to 65, that's also putting in, additional new notice requirements and that's a benefit to the tenants. Is that correct?
Yes, sir.
And then finally, we have this horrible situation when it comes up of there being criminal activity on a property, and what we're trying to do there is protect other tenants that live, in those facilities, around those facilities, in case to keep them from harm or violence. Correct?
You are correct.
So that's holding people accountable while protecting those tenants that will remain there. Correct?
Yes, sir.
I really appreciate you bringing this. I think this is extremely common sense. We've debated this issue in here for years. We've had several pieces of legislation. One I was involved very much so with a few years ago, and we've been trying to do some things to protect the rights of tenants in Georgia for a long time, and I think you've done a great job with the balance you struck here. So thank you for bringing it before us.
Okay.
Thank you.
All right. Thank you. We'll move on.
Yes, sir. I'll slide
Don't see
right
any more
over.
questions. All right. I want to ask for Lieutenant Klaus Buck to come up, please.
Right here, sir.
I'm sorry?
Right here, sir.
Oh, okay. Thank you.
Just announcing my presence.
Let me have that water.
And I might.
And the pistol.
Maybe a water pistol, but thank you, Mr. Chairman. Ladies and gentlemen, I really appreciate y'all hearing me. I'm probably a little in over my head. I'm Lieutenant Buck with the Fulton County Marshal's Department. I've been authorized by my agency head to speak on this matter. Begin with, we have absolutely no opposition to the majority of the provisions of this bill. I'm a little hamstrung. I do have to apologize. I didn't get a substitute version of the bill. I got the original version of the bill, but I don't believe that it's the changes are all that significant from my point of view. What I'd like to address is the possible consequences of the 14-day expedited execution provision for criminal activity. We fear at the Fulton County Marshal's Department that this may cause an undue burden to the Marshal's Department's already limited resources. Moreover, it could even create an unwholesome churn within the entire eviction process. I think I'd better back off and go do a little bit of background here. Again, I'm with the Fulton County Marshal's Department. We are one of the busiest civil departments, as in we serve civil process, execute civil writs and orders, not just in the state of Georgia, but in the southeastern United States. I just texted my eviction division commander a couple of hours ago, and I asked him exactly how many evictions did we do in the last calendar year, 2022, and he informed me that we did 3,824. That's evictions. That is physically going in there, making entry, putting out property, and often people. So that's an enormous volume of business. Okay, so this is our thing. This is our bread and butter. Lots of people do some of the things we do, but we are the principal eviction department for the largest county in the state of Georgia. In the state of Georgia, 1 million souls, over 1 million souls under the last census.
Now, so our concern is, I got a couple of concerns about it. First of all, we may simply not have the resources to execute within the 14-day execution period. If every person was dedicated to it, it may not be achievable. Even if it is achievable, it can create what I would call an unwholesome churn within the system, where every time a writ is issued based on criminal activity, it moves to the front of the line ahead of all the writs that aren't issued based on criminal activity. And it just keeps pushing the other writs further and further back, with the criminal activity writs churning forward and all the others being pushed back. Another point is, when we're talking about evictions, it's not just a question about the marshals not being able to get the requisite number of deputies out on the scene. It's also a question of labor. A lot of the delay is simply beyond our concern. We provide the labor. We provide the deputies. We go out there with a writ in hand. Our mandate is to execute the writ, which is effectively a court order, and we maintain the peace and make sure the rights of all parties are respected. The labor is provided by the plaintiff, and in the current job market, that's simply not available in abundance. So a lot of delays have less to do with a sufficient number of deputies executing writs or deputies executing writs with sufficient speed, but with the availability and the quality of the eviction labor itself. The ladies and gentlemen who put their hands on the property and put it out of the tenant and put it outside. Another concern that I have is, by reading the bill, and again I'm reading the original version at the substitute. I apologize for my oversight in not obtaining the substitute version of the bill. Is that my plain non-lawyer reading of the bill is that in order to get this expedited treatment, it is sufficient to merely plead criminal activity. Particularly in cases where there's default, there will be no evidentiary hearing as to whether or not the criminal activity actually exists. This would create an unwholesome incentive to simply plead criminal activity, no matter what the facts actually are. Now, I'm not a lawyer. I'm not a lawyer of any sort. I'm not a dirt lawyer, no other kind of lawyer. But my non-lawyer self can probably figure out a way to falsely allege criminal activity in language sufficiently vague where it's not defamatory, and that it doesn't leave me open to any real possibility of conviction for or being charged with false swearing. Because again, the underlying pleadings for dispossessory proceedings are affidavits. So I can see an unwholesome incentive there. Most landlords are good, honest, decent human beings, just like most of the human family. However, we don't put locks on doors for honest people. There's always the bad actors, and they will always have a disproportionate impact. So I'd like to make a couple of suggestions, and I already made a proposal to the sponsors of the committee, and I'd be happy to share that around. I have photocopies of that for improving the bill. I would suggest one, that the expedited treatment only be provided in cases where the court explicitly orders, "Hey y'all, this is bad. Hey hey marshals, hey sheriffs, hey constables. There are bad actors on these premises. They've done bad things. They're fixing to do bad things in the future, and y'all need to hurry up." Okay, and this should be done only after an evidentiary hearing. Obviously, if the dispossessory proceeding goes to trial, it can be incorporated as part of the trial. A judge will simply say, "Hey, I see you're asking for expedited execution, 14 days. What evidence have y'all got?" And they'll provide the evidence. And in the case of default judgments, which are quite common in dispossessory proceedings, they're particularly common because service by tack and mail is authorized. In a situation like that, I believe there should be a special hearing where notice is given to both parties, where the judge says, "Look, plaintiff, I need you to show me, landlord, plaintiff, I need you to show me why there should be expedited execution." Also, I think there is such a thing as righteous delay in evictions. We delay evictions sometimes at the request of the plaintiffs. Okay, for example, we're evicting a place which is unlawfully being used as an adult as a nursing home, for lack of a better word. Obviously, if the occupants are doing illegal things or even behind on their rent, they want an eviction done, but no landlord wants to see the elderly cast out into the street. So there may be a situation. Let's delay this until Adult Protective Services can do the necessary work. Other times there are circumstances where speedy eviction is not a good idea for public safety purposes. For example, if there are hazardous materials stored on the property, under the law, what we're directed to do is we're directed to put out all the former tenants, the defaulting tenants, and the other occupants, and put their personal property outside. One of their personal property includes barrels of hazardous materials. Arrangements have to be made for the proper disposal, so there should be a safety valve in effect where the executing officer, a sheriff, a marshal, a chief constable responsible for executing can say, "Hey, Judge, we've got your order, but we cannot comply in the spirit of preserving the public health and safety, and this is the reason why." And the executing officer should have to go on record and make a sworn statement as to why there's a delay occurring. Again, I think that summarizes pretty much everything I have to say. I'm not opposed to this bill. I'm not opposed to being held to standards. I'm not opposed to serving the public. I've done it for nearly 25 years, and I'm proud to do it. People sometimes ask me, how do y'all do that? How do y'all evict people? How do you live with yourself? Isn't that horrible? And my response is, I don't view it that way. I'm not there putting anybody out. I'm the impartial referee, preserving the peace, making sure that both sides get their due. Sometimes the landlords hate us worse than the tenants do. We're there as peacekeepers, and I appreciate being heard, and I appreciate my small contribution being allowed in.
All right, you have a few questions, Representative Hong.
Yes, thank you, Mr. Chair. I remember at one point we had counties where we did not require the sheriff or the marshal to come out and actually execute the writ, where they were able to go ahead and hire a private company. And if law enforcement was required or needed, they would be called. I know at one point Cobb did it, and then they changed it where now it's required to have sheriff to evict. Do you know why?
I'm going to. I'll answer in a one answer format, and then in a one sentence format, because
Sure.
it's the law. There's a case that came out of DeKalb County that relates to the I can't recall the case or the style of the case. It's the forgive me, I do so apologize. Relates to an extended stay motel.
Right.
And the Georgia Court of Appeals goes on to say if there's a landlord-tenant relationship, the dispossessor proceeding must be followed. If there's merely an innkeeper-guest relationship, then their summary removal is authorized. And I guess the other point is what the court does is the court issues a writ. The writ is a command that runs to the Marshal of Fulton County and her lawful deputies, including me, commanding her and her lawful deputies, including me, to put out the defendant / former tenants and turn quiet possession over to the landlord. So it is by its very definition a judicial procedure based on a writ issued by a judge and executed by an officer of the court, specifically me, a sheriff, a constable.
Okay, good. I've always wanted to know that, because at one point I've had clients that didn't have to go through, and then counties got strict about it. My next question, and this is, and because you're law enforcement, I'm asking you. I've represented tenants, roommates, with criminal activity, criminal charges, and before a conviction, having to get them out sooner than later, but us having to follow the procedure. So I understand Chairman Carpenter's intent of putting that in, but do you think that if we put that language in, then essentially we're making dispossessory magistrate judges to decide whether or not somebody actually did commit a crime, and now we're making that judge decide whether or not they're essentially having a criminal trial in front of a dispossessory proceeding judge.
I mean, my distinction would be, in my humble opinion, is that obviously it's proof beyond a reasonable doubt in a criminal proceeding. A civil proceeding generally is by preponderance of evidence, maybe by clear and convincing evidence. There's already an analogous proceeding used throughout the state. That is the family violence and stalking TPOs. The underlying activity is in fact criminal, often criminal activity of the most of some of the foulest sorts you're likely to include. But as I always, I'm a deputy marshal, I'm also an instructor at our academy, I always point out, TPOs, family violence TPOs, restraining orders, these are all civil remedies, and there'll be a different burden of proof there.
Correct, but we're not talking about that. In this specific language, we're saying if anybody's been charged or convicted, so charged as Chairman Carpenter pointed out, that if somebody's been arrested for criminal activity and in fact you are issued a writ based due to criminal activity, so therefore you're having dispossessory proceeding judges decide whether or not that person, the tenant, whoever, the defendant, tenant, committed a criminal activity. Do you not?
I follow where you're going in this. Often, I'm no lawyer, but this is what happens at the confluence of civil remedies and criminal prosecutions. But I would argue that obviously the criminal justice system is concerned with guilt or innocence beyond a reasonable, or guilt beyond a reasonable doubt, I should say. On the other hand, a judge, an eviction judge, for lack of a better word, an eviction court judge, would be concerned with proof. I would advocate for by a lower standard, let's say by preponderance of evidence or clear and convincing evidence, and also that there would maybe be a requirement not only that something happened, but there was evidence that something was going to happen in the future.
I understand, and I like the intent of it. I'm just, and I also do criminal defense, so I'm sure my landlord clients would not have liked that question, but I'm just concerned with that part. So, but thank you.
I don't know if anybody's interested in again or not. This references the old original version of HB 404, not the substitute version. But I don't think the change makes any the substitute version makes any substantial changes to what I'm concerned with. I did create some language that I thought might be helpful. It was already sent to the sponsors, but I don't know that everyone here is a sponsor. Are y'all at all interested?
Do we have it?
There you go. One just for me as a souvenir of my
Representative Kelly.
Thank you, Mr. Chairman, and I want to just follow up with the lieutenant. Thank you for being here, with us today. And you certainly have a unique perspective, and it's great to hear from you. And I'm sorry you haven't had a chance to see the substitute, because my understanding is that the author did work pretty intently on trying to clean that up some, trying to not necessarily have an open-ended situation. This now does say that criminal activity means either a charge or a conviction for a crime, and we really have two types there of charges or convictions. Either subsection A, where in the previous 6 months they've threatened the health, safety, or welfare of the other residents, the landlord, or landlord's agents, and then the second is a criminal charge or conviction in the previous 6 months for a crime against a person or sexual offense prohibited by Chapter 5 or Chapter 6. And I think, we've tried to be narrow in our writing of this. These are the worst of the worst crimes where this 14 days is going to come in. we're talking about, Chapter 5 is homicide, assault and battery, kidnapping, false imprisonment, reckless conduct, cruelty to children, feticide, stalking, elderly abuse situations. That's the chapter 5. So, we're cognizant of your caseload, but there are situations where we believe there needs to be guide rails. So it's not just the pleading of criminal conduct. It's actually being able to show the court, hey, here's the charge or the conviction. We should have that documentation. And then the court will get to have a dispossessory proceeding within 14 days to where, again, that's where the evidentiary situation will come in with the court in terms of can the landlord, looking to evict, has to prove that they were charged or convicted. Does that help some of your concern there with just the pleadings?
If I may, first of all, I want to begin by saying thank you for hearing me. Thank you for hearing me. I'm most cognizant of the honor I have of being heard here. I would begin by pointing out that Chapter 5 of Title 16 does, in fact, encompass within its boundaries some of the foulest crimes known to jurisprudence, including things like murder and feticide and stalking. It also encompasses within its boundaries some pretty trifling stuff, such as simple assault and simple battery. Mere intentional offensive physical touching. So, there's to say that everything that falls under Chapter 5 of Title 16, which is crimes against persons, encompasses merely the worst of the worst is not quite correct. And the other concern that I have, even if we take your view of how the law will be construed, which is certainly reasonable because you're one of the authors of the law, I believe. Am I correct?
No, just an interested party here as a committee member.
But as a legislator,
just trying to save a poor, desolate soul wandering in the ocean.
As a legislator, your judgment is certainly of extraordinary significance. But even if the judge does say, yeah, I'm going to before I mark this writ, hey marshal, expedite execution here, I'm going to make sure that at least there's proof of this criminal activity by preponderance of evidence. What of the myriad cases where judgment is obtained by default? The law in the state of Georgia, and I apologize if I'm being pedantic here, allows me to knock on the door, attempt to perfect personal service. If I'm not able to do personal service, notorious service, leave it with someone of reasonable age, of legal age and understanding who resides at the premises. If I don't get an answer, I tack and I mail. That's what the law directs me. So theoretically, it could jump straight from attack and mail service, where in fact criminal activity has been pled to the magistrate judge acting effectively, or whatever trial judge it is, acting as a rubber stamp, saying, "Marshal, expedite this," and it's a pretty good bet, based on my experience with landlord-tenant law, that a lot of tenants simply default. They simply default. They fail to answer within the 7-day period that they are authorized to answer by.
And we can't do anything about a tenant who just chooses not to respond to a lawsuit or to an eviction proceeding. We just can't do anything about that. I mean, so how do we protect the tenants who are living there with someone who has potentially committed a very violent crime? How do we protect them if we're trying to balance here? And I'm always cognizant of when we put burdens of how they affect and trying to figure out who should the burden be on. Should it be a burden on the system to try and get this expedited because the other people living around, again, a potentially convicted violent offender, is it worth it? That's what I mean. I think it is. That's just kind of what I would ask. And if they're not willing to respond, we can't do anything with the person who chooses not to answer. And so I don't know how we get around that.
Well, I would venture to say that in the case of a default, if a plaintiff / landlord pleads criminal activity, I would argue there should have to be a hearing. A notice of a hearing gets sent to both parties, including the defaulting tenant. Show cause why a landlord, go ahead and show cause why an order to expedite should be granted.
But if they're not responding to the initial dispossessory filing, why do you think they would necessarily then respond to a notice of a court hearing?
And you are almost certainly correct 99% of the time. But the point is this still requires the landlord to show some evidence, might only be mere preponderance of evidence, which is a pretty low standard when nobody is there to oppose them, that there is grounds to expedite it and to order the marshal to put this writ ahead of all of the writs that are not relating to criminal activity, because that's what it is. It isn't just a question of, hey, marshal, hurry up. It's, hey, marshal, hurry up, and preference this criminal activity based writ over writs that are not based on criminal activity.
And I think you're exactly right. And I appreciate it. We are asking for preferential treatment here, and I would argue that it's worth it. You know, as a landlord, myself, I would hope that the other landlords would be understanding that my just regular eviction for someone maybe not paying, paying their rent should take a back seat to someone who is trying to get someone evicted who's a convicted sexual offender. And I mean, I think you're right. We're asking for preferential treatment, but I think we all should, as a body, be able to agree there's times where it's absolutely worth it if it could save one extra life.
And I agree 100% with you, sir, that preferential treatment should be given to bona fide cases of bad actors when there's evidence that the bad actors will act badly in the future. But there should have to, but merely the landlord, merely the tenant/defendant defaulting does not necessarily prove that exists, and does not necessarily say that should not in and of itself say that the writ created in that case gets preferential treatment.
And if I can, one more, Mr. Chairman, because I want you to help me game this out. Okay, a landlord who is a potential category here, or excuse me, a tenant who potentially falls into the criminal activity expedition.
Okay.
Knows that they're in that class of tenant. They know that there's been a pleading that could potentially evict them within 28 days maximum, 14 days for a hearing, 14 days for once a writ's been issued. If they show up, if they answer, they have 14 days to have a hearing, and then 14 days if the writ's actually issued. So potentially a 28-day maximum exposure. If they know that they have this shortened timeline, and you're saying maybe we need to take out the default, why wouldn't they just default every time to have the extended timeline?
Default would not pull under my proposal as I'm envisioning it, and forgive me, would not pull expedited execution off. Would not put it off the table. It would simply say, landlord, come in and show why you should get this special, extraordinary remedy. If the defendant chooses not to show up, then the landlord will go up and present his evidence. Again, I'm not a lawyer, but I might consider this analogous to even when a defendant in a civil action defaults. I believe under many, though not all circumstances, the plaintiff is still required to prove his damages. Am I correct?
That is correct. You have a separate damages hearing. That's correct.
This would be analogous to the damages hearing. Now, it would all be rolled in together. If it went to trial, it would all be rolled in together as part of the evidentiary the evidentiary phase of the trial. But if it weren't,
let me just interrupt you for a minute, because here's where this is different. When I make a pleading in a personal injury case, I don't ask necessarily for a specific damage, monetary. So we have to have an evidentiary hearing for me to prove my damages, not to prove the conduct. When we have a damages hearing, it's not for me to prove the conduct of why I'm owed the money. It's for me to justify why I'm due the money. What we're talking about here, we know what the remedy is here. There's nothing for me to show up and say, I need. my remedy in a dispossessory is for the eviction to occur. It's not to talk about the conduct for the default. The default is given based on your non-response. That you take conduct off the table at that point. And so we already know what the remedy is for awarding damages in a dispossessory, and that's just where I would draw the distinction. And Mr. Chairman, I know I've asked way too many questions down here, and the hour's getting late. But I thank you for indulging me, and thank you for being here and responding.
May I make a quick response?
Of course.
Perhaps this is more analogous, and I know it's obviously it's the opposite end of the civil spectrum. Maybe it's like akin more to equity. That if I go in front of a superior court judge and I plead for a restraining order or an injunction, I have to show something extraordinary. In order for some extraordinary remedy, for some special treatment to happen, not merely for me to be compensated for the damages that I'm suffered, but that the bad actor might be enjoined for future acts of wickedness, special proof has to be given, and I would suggest that would be applicable here on the opposite on the opposite end of the civil law spectrum.
And I thank you for that. Final thing I'll say is, we do have, some very real penalties for people that lie on pleadings, and that you're always going to have bad actors, but this whole situation gets remedied, if you will, if you have a tenant who's already had bad conduct is responsive to the court the way the law intends them to, and that's what we're trying to talk about here. Thank you, Mr. Chairman.
All right. Representative Reeves.
Mr. Buck, thanks for coming. A couple of questions. I think the substitute intended to say an actual charge or conviction. So if anything needs to be tightened up, wouldn't you agree that if it required an actual pending charge or an actual conviction, that's something that in law enforcement you commonly can verify and do verify?
I would venture to say, first of all, it's not necessarily for us to determine whether to be expedited. I would imagine the court would label the writ expedite 14-day execution. Right. And again, certainly it would be you're absolutely correct. It would be an improvement.
Okay.
I mean,
wouldn't you want to get criminals out of Fulton County if you verified, number one, they've got pending charges, number two, there's been a writ of possession issued for them? Isn't that the kind of person you want to have, on the move?
Well, I would
venture that might help.
I would venture to say that out of the location, certainly is what will happen. Out of the county is a greater leap from your lips to God's ears, so to speak.
You mentioned, and also writ of possession or the eviction. There's a form that is that the clerk's office gives for landlords to use, and it has rent and other liquidated damages items to fill out, right? So that the tenant, whether it's tack and mail or actual service, they have the damages all laid out there, and they can decide whether to contest it or not, right? It's not like a 10-page legal pleading where you don't really know what the damages are. It's pretty straightforward on a one-page document, right?
Yes, sir.
All right. And if they don't answer within 7 days, there's an additional 7-day grace period, so it's 14 days to get default, right?
No, sir. That applies in personal property foreclosure proceedings relating to that personal property foreclosure proceedings. The standard in dispossessory proceedings is 7 days.
And you're saying in Fulton County they don't give a 7-day grace period?
There is
for
no
default.
there is no grace period to reopen default. The statute. I've read it numerous times, and I actually teach it. Is 7 days to answer.
All right. Once in Fulton County today, if a landlord were to get a writ of possession today, what is the earliest they could get scheduled to get that writ carried out?
I can't even begin to answer. I can't even begin to theorize.
What's an estimate?
There are so many different alternatives. For example, if a landlord we call it plaintiff labor, where a landlord hires his own labor either casually or utilizes, or like let's say an apartment complex utilizes their maintenance crew to do the eviction. Right. Things can go quite quickly. If on the other hand they contract with one of the many labor providers, it really is to some extent on the sufferance of we can't execute until the eviction company provides the labor.
All right, so today, if a landlord comes into Fulton County with a writ of possession and says, I have a labor crew and I'm ready to carry out this writ of possession, what's the earliest they can get their eviction scheduled?
I wouldn't feel comfortable answering.
You can't give an estimate to this committee?
No, sir, I can't.
All right. Are you aware that, you know, in late 2022, it was pretty common around Metro Atlanta for there to be a delay of months to carry out evictions?
I'm quite aware of that.
And
I hear the complaints all the time. But with respect, a lot of that has less to do with the willingness and enthusiasm and skill of the Marshal's Department, and more to do with the availability of labor to do the actual work.
But-
It's
Go ahead.
to quote Forrest Gump, an eviction, or paraphrase, an eviction is like a box of chocolates. You never know what you're going to get. It may be the landlord may have the tenant may have moved themselves out and may have only left the nastiest of trash behind. Other people may have been other folks that may have been hoarders and have decades worth of mementos and knickknacks. Full basements, full basements that are an additional floor, full of surplus furniture. It's a wild card situation.
Representative Crawford.
Thank you, Chairman. Lieutenant, thank you for your testimony. I think when Representative Kelly asked you a few questions dealing with criminal activity, I wanted to go back to that. As the language is right now, that if there is a criminal charge or conviction, if we're looking at 87 through 89 of this substitution, anyone who, if they violate a crime in Chapter 5 or Chapter 6 of Title 16, I think one of things that you were saying is that can be somewhat vague. And so we might be covering some of the worst criminals, but then also, unfortunately, there might be certain instances or offenses that aren't the worst.
Absolutely. It can run all the way from cold-blooded, premeditated murder for hire, all the way down to a slap fight between two ignoramuses. I mean, literally, or even in the case of assault, where there ain't no fight at all, simply an offer of violence coupled with the apparent ability to follow through.
Thank you, and I think for that reason, I would like this if maybe we could specify in this language what type of crimes we were actually speaking about, if the sponsor would actually be open to that.
Yeah, we can talk through it.
Let's let this whole process play out. It's gonna be a long day. Obviously, we can touch on that stuff as we move forward. We got a lot of people here to speak on this bill, so I think it'd be wise from a prudent to let this thing roll for a little bit. But yeah, I hear you.
Anything else, sir? I'm sorry.
No.
Forgive me. Did I answer the question, or did I just think I was being clever?
I can't answer that, but you did answer the question.
All right, I don't see any more questions. I don't have anybody else signed up, but I know there's others here that want to speak on it. How many do I have?
Thank you.
I do apologize. This is my failure, and I don't want to disrespect the rules of the committee. I do have, Ms. Johnson had to leave. We do have two lawyers from Legal Aid, and myself, and from Atlanta Volunteer Lawyers Foundation.
So we got 3?
Yes, sir.
Can y'all make it quick, please?
Yeah, can we come up together?
You may. You may.
Here, you want this chair? Move on that. Thank you. You got it. The seat's a little warm. Sorry. That's what we call the hot seat there, ma'am.
So, Lindsay, you want to go first?
Sure.
Okay, if you would, as each of you speak, introduce yourself, tell us who you represent, and then go from there.
Absolutely. Good afternoon, Mr. Chairman, members of the committee. Thank you for letting us do this when we didn't sign up. I apologize about that. My name is Lindsay Siegel, and I'm the Director of Housing Advocacy at the Atlanta Legal Aid Society. Atlanta Legal Aid is essentially a nonprofit law firm. We represent people who otherwise wouldn't be able to afford legal representation, and we do that for free. We represent them in civil legal matters, so we have expertise in a number of areas: family law, public benefits, home ownership interests, but we're especially and particularly concerned with landlord-tenant issues. It's really these days the greatest number of calls that we get to our office. I've personally been doing this work myself for over a decade. I've represented hundreds of tenants. So I have a lot of sort of practical experience, and I can answer some of these questions about, how it really would play out in court. I can also tell you that I happen to be a landlord. So I'm not unsympathetic to, what the issues that landlords have and the concerns about evictions. One of the things I would say about the pandemic is it did slow down the court process, but I think it would be short-sighted for us to make a law now that looks at those timelines, because most of the courts in our state have gotten caught up, and the ones that haven't are on their way to getting caught up. Before the pandemic, the timeline for evictions was about a month, and shorter if the tenant defaulted. One of the things that I heard some of the comments about sort of tenants defaulting, and why are we sort of concerned about tenants who don't bother to answer the warrant. I'll say first that there are a lot of reasons that tenants default. Most of the time, it's not that they're unconcerned about their living conditions. It's really, there's a 7-day answer period. It's the shortest of any answer period in Georgia. Sometimes tenants are in the hospital and they don't know about the eviction. Sometimes they're out of town dealing with a family member who's sick or has died. Sometimes they don't read, and so they don't know what the warrant says, or they can't understand it because they don't have the education that we have, and they just don't understand what it is. Or they can't get off work because they have a job that's during business hours, so they can't get down to the courthouse to file their answer. And the other way to file an answer is online, and in most places it costs $20-something to do that, so they don't have the money to do it. So there's a lot of reasons that a tenant may not file an answer. That doesn't mean that they don't care about the case. So one thing that I would talk about just since we were last talking about the sort of criminal exception, I really worry, just as a practical matter, that this is going to be really a nightmare. I think it's going to be a nightmare for the courts. I think it's going to be a nightmare for tenants having to sort of defend this claim that they have committed a crime that maybe they've only been charged with. And we are talking here about crimes that include really just slapping or maybe a punch that somebody could be charged with. And there's been, no criminal court that has found them guilty of that crime. But then the landlord may use that as an excuse to try to expedite a process. In my experience of representing, again, hundreds of tenants, criminal activity by a tenant as a reason to evict them is exceedingly rare. The vast majority of cases are non-payment cases. And so what I think this is going to do is it's going to provide an incentive for landlords to assert that there was criminal activity when really the main issue is non-payment. And all they would have to do is say, well, this is both a non-payment and a criminal activity issue. So I want to avoid the notice that would be required under this bill, and I want to expedite things simply because a tenant may have been charged with a crime. So I think it's going to become a practical problem, and I think the courts are going to have an issue holding these essentially sort of pseudo-criminal trials to determine whether a tenant has actually committed a crime. And here in this language, there's not really even a process for doing that because there's no standard for review for the judge to determine whether a crime actually has been committed. It truly is just this allegation that a tenant has been charged. That's it. Under this current language, that's all that would be required to cause the expediting procedure to happen. So I think that's going to cause a lot of problems. I'm glad that the marshal talked about the practical problems on their end, so I won't repeat that. But I think what it does is it provides this incentive to essentially abuse the process, so that, a landlord that doesn't want to wait the month or month and a half alleges this to try to get a tenant out sooner. Most often, criminal activity really comes up in the subsidized housing context, and in that context, even when we're talking about people who are living in subsidized housing, there's a much more robust procedure than we're talking about here. So I think that I'll just leave my comments there for the criminal activity. I don't know if you want to add something else on that, and then we can maybe talk about the other subjects.
Sure. Hi, my name is Crystal Redd. I'm the co-director of the Safe and Stable Homes Project at the Atlanta Volunteer Lawyers Foundation. And I definitely want to reiterate what Lindsay has talked about. One of our concerns is that particularly with the, who defines this, what's written here is a threatening the health, safety, welfare of tenants and other landlords and property managers and other staff who are working in that office. Because I think let's see, that's line 84. We've been focused on lines 87 through 89, where we're having a specific reference to Chapter 5 or 6 of Title 16. When you look at lines 84 through 86, that's much more vague in the sense of describing what that could mean. So that would be a concern that the vagueness of it would allow for the abuse, and that's exactly what Lindsay was talking about, that landlords would be, could have the motivation to include some particular crime. We're also concerned about that this doesn't make any reference to something that's happening on the property. Particularly for lines 84 through 86. There isn't anything in the language about it being on the premises. And perhaps that may be something that you would have for lines 87 through 89 when we are referencing these more serious violent acts. And I know that there's been discussion about defining that in later conversations, but I'm not really, with 84 through 86, there isn't a particular, and I don't know, and I'm not sure here for 84 through 86 if you are imagining that including less serious crimes, and so therefore, I think a tie to the premises would make that even less vague. So those are the particular points we have about the criminal acts. The practicalities of it, the lieutenant brought it up as well as far as this piece of timing, how it actually works with an eviction process. One other point that we had here was the impact on an entire household for the acts of an individual. So how would this work if there is an expedited process for a person, one of the household members having allegations against them? Will the entire household then be impacted by this expedited process? And so there's no way that that's being discussed or being addressed in the current language. So that would definitely be a concern. Again, not only it just being a charges, but then how it impact everyone else who lives at the home. Do you want to go ahead and I can go to the right to cure part? Or I'm sorry, go ahead.
Mr. Chairman, members of the committee, my name is Elizabeth Apley. I'm an attorney, and I'm here representing Enterprise Community Partners, Georgia Advancing Communities Together, the Georgia Supportive Housing Association, Presbyterians for a Better Georgia, and 9 to 5. We're kind of starting with the end with the criminal provision. The research that I've done has shown that this is a particular problem in domestic violence situations. You may end up evicting the victim of a domestic violence crime. Very often in domestic violence situations, regrettably, law enforcement will arrest both parties and say, let the court determine who's the aggressor. And so you end up in that situation evicting the person who is a victim rather than the perpetrator. We also know that in situations of people involved with mental health or behavioral health issues, that you end up with an eviction that disserves the public interest. And, Mr. Chairman, the Department of Health HUD has determined some 7 years ago, it found a disparate impact in the criminal conviction of black versus white males and black versus white females. And as a result, they have interpreted that disparate impact to impact the protections contained both in the Fair Housing Act, which prohibits discrimination based on race. And so once you start implicating criminal activity into the housing situation, you are affecting the protections under the Fair Housing Act, under the HUD guidance, which was reiterated as recently as this summer. Our suggestion in the language that I believe is in your folder on the last page proposes that the crime has to be one committed by the tenant. The language, as I read it in the sub and in the original bill, does not say it has to be by the tenant. So if you're going to evict someone for a criminal act, it has to be the tenant who has acted. That language also proposes that the crime has to have been committed on the premises, and that the danger has to be significant and immediate to the health or safety of other residents, the landlord's agents. We're not trying to limit that other language. But I think that language tried to narrow the situation to one where there really is a crime which has been committed that poses this kind of significant threat to the health and safety of those on the property, and that the tenant, him or herself, be the one who is the actor.
Okay. Representative Oliver.
I'm concerned about the criminal new right to evict myself because of complications and vagary, but I want to ask you to look at lines 54 and line 63 about the 3-day right to cure. Okay. I really don't understand why we can't expand that 3 days to at least 7 days. I mean, I'm rich and I couldn't organize myself to do anything in 3 days to move out.
So, Madam Chair, Ms. Siegel chose to start at the end, but I would like to address all the issues. And so the right to cure is one that I've been advocating for the General Assembly this will be the 4th year. And Georgia is an outlier in failing to provide a notice and right to cure. The American Bar Association adopted 10 guidelines for eviction without objection from their real property law section last February 14th, and the first is to provide a notice and right to cure. This chart, which I know I've provided to many of you over the past few years, these are the how quickly you can get someone evicted. Georgia's tied for the 3rd fastest. What's critical about this chart is these gold boxes are the days providing a right to cure in all these other states. And so Georgia, Alabama, Mississippi, North Carolina, all of our neighboring states provide a right to cure that Georgia does not provide. Right now in Georgia, the landlord can give an oral notice and then immediately go to court and file that eviction. And the research is that an eviction and an eviction filing, let me add that the research is that the face of eviction in Georgia is black women with children. Black women are 2 to 4 times more likely to get evicted than white women who are similarly situated socioeconomically. And if they have children, the risk goes up even higher. And so when the research shows that the effect of an eviction, and there's a 16-year study of pregnant women in Georgia published in the Journal of the American Medical Association in late 2021, finding an association with eviction during pregnancy with low birth weight, prematurity, and multi-generational consequences. And a national study that shows the risk of eviction as manifested in an eviction filing had those same adverse impacts on fetal outcomes. So when you look at the range of what our neighboring states here across the country and in the Southeast have done, you can see that 3 days is a minimum. And as Representative Oliver stated, the notice, we thank, and I didn't start by thanking the author for bringing this bill.
Just do your thing, baby.
I love Casey Carpenter. I know I'm not supposed to say it.
Just pure love of people.
That's right. No, he's been very generous with his time, and I appreciate his advance in the conversation. But what we have here, that he's made it written, we thank him for that. But as Representative Oliver said, 3 days is not long enough to either vacate effectively or to pay. And so many leases now provide a grace period of 3 or 4 or 5 days. And so what we're asking for is 7 days, and that's what I've proposed in the amendments you have in your folder, so that people, it's a minimal amount of time, but the goal is to keep families safely and stably housed. Mr. Chairman, Georgia law adopted in 1991 finds that it is the state's policy to provide decent, safe, and affordable housing to all segments of the population of this state. That's OCGA 83171. So this legislation begins the process, and we're asking this committee to fulfill the promise that 404 holds. The right to cure also, as originally introduced, provided that the notice to the tenant to depart be posted on the door, tacked on the door, and then delivered by statutory overnight delivery. That was changed in the sub to eliminate the statutory overnight delivery and instead provides only for the tacking and whatever else is provided in the lease. But we know that leases in this state are boilerplate.
All right, any major other changes you want to advocate?
Yes, sir.
'Cause we're
Yes,
running
sir.
out of time.
I understand.
Running long.
Very important. So the promise in line 18 of the sub that premises for rental residences be fit for human habitation. The Uniform Commission on Laws, more than 50 years ago, determined that uniformity was absolutely essential to provide this basic human protection. And so that URALTA, the Uniform Residential Landlord-Tenant Act, has been adopted by 29 other states, including all of our neighbors here in the Southeast. 50 years ago, Alabama, North Carolina, South Carolina, Tennessee, Virginia, Mississippi, they've all adopted it. And what that standard adopts is, and I've just taken a portion of it and put it in the amendment that's before you. If you look at the first page, it amends Section 2 on line 17. It incorporates the requirement that habitability is defined by the landlord complying with the requirements of applicable building and housing codes that are material to affecting health and safety. That, these are make repairs to keep the premises in fit and habitable condition, keep the common areas clean, maintain in good and safe working order and condition all electrical, plumbing, sanitary, heating. You get the picture. This is rather than waiting 20 years until the courts determine what fit for human habitation is. This has been the law in all of our neighboring states, Mr. Chairman, members of the committee, for 50 years. It's not unworkable. It does not impose a burden on landlords that cannot be managed. And then the second part of that, Mr. Chairman, is that beyond defining the standard, we have to provide a remedy. There has to be a consequence for failing to provide premises that are fit for human habitation. The statutory law in Georgia makes clear that the obligation to pay rent does not abate if the property is destroyed, if it's condemned, the obligation to pay rent continues. So we have to have a remedy in order to give meaning to the promise of fit for human habitation. And that's what you see in subpart C at the bottom of page 1 in the amendments I've proposed. To terminate the rental agreement after the landlord's had an opportunity to repair, to sue for damages, alternatively to withhold rent, to pay into a registry. All of these things are possible as a way to give meaning to that promise. I think that the best thing I can say to you on this issue in Section 4 of the cap on security deposits is the author's repeated statements to you that the vast majority of landlords only charge 1 month. If we go to 3 months, as we're going to be making it impossible. We have thousands and thousands of family paying $2,000 a month to live in these extended stay motels. Schools are sending buses to these extended stay hotels every school day of the year to pick up these children. And a big part of the obstacle from their moving out of those miserable conditions are the inability to come up with the security deposit, the utility deposit, et cetera. So we don't want to make that burden harder. And so on the right to cure, the other point I was going to make, beyond extending it from 3 days to 7 days, please allow for, if you're not going to allow for the statutory overnight delivery in addition to the tacking, please provide for texting or emailing, some way to communicate with the person other than just tacking on the door. And also, the protection should include those people who violated their lease in a way other than non-payment of rent, perhaps by having someone who's not on the lease living there or leaving the laundry on the balcony, or those people should also be protected. And the language I offered to the committee is also there. On this issue of the notice and right to cure, which encompassed all of these, Chairman Cooper's legislation had the support and continues to have the support of all of my clients, as well as Voices for Georgia's Children, Children's Healthcare of Atlanta, the Academy of Pediatrics, the United Way of Greater Atlanta, the Community Foundation, Georgia Watch, 9 to 5, the Housing Justice League, the Statewide Independent Living Council, the American Friends Service Committee, the Georgia Early Education Alliance for Ready Students, the Central Outreach and Advocacy Center, and the Georgia Affordable Housing Coalition.
Okay, all right. I got a couple of questions for you. Representative Kelly.
And I'm going to be brief, Mr. Chairman, because I know we're trying to move through this. And I'm looking at Section 4. In Georgia law today, is there any protection to a tenant for how many months of a security deposit a landlord could ask for?
No, sir.
So is it better or worse that we have Section 4 in this bill, or should I have an amendment to strike it?
I think it's worse, frankly. 29 states have a cap on security deposits. According to our research, 14 provide for 1 month, 11 provide for 2 months, and there are 3 that have apparently, there are 2 that have 3 months. One of those is California, and we're not allowed to follow California.
Except with cosmetology license, we're actually trailing in that.
That's
Sorry, different story for a different day.
Help me understand, though. Help me understand, Dave, if a landlord wants to require a year's worth of security deposit, and now we're saying they can only do 3 months. Tell me how that's worse.
Yeah. And I would tell you that I think I've seen hundreds, maybe thousands of leases. I've never once seen even 3 months for security deposit. And I think what this does is it invites the suggestion that 3 months is now reasonable, and that some landlords are going to take that as the standard then. And they're going to actually set their security deposit at 3 months. I think you also run a risk, if you address security deposits and you don't address non-refundable fees, I think you run a risk that everything then becomes a non-refundable fee, which is sort of where we're already heading, where a lot of landlords, instead of charging a security deposit, because that has to be returned at the end and is subject to the Security Deposit Act, they'll just charge the same fee, but make it a non-refundable fee, and the tenant then has to pay that. And that's a huge burden on low-income tenants who are trying to find housing.
Okay. Agree with it, but I heard you.
Representative Reeves.
Councilor Apley and colleagues, thanks for providing this information. The request amendments you gave, did you give them to the sponsor, Mr. Carpenter?
Oh, yes.
You've given them to him? Good.
I papered him up good.
I wish it was on the audiobook, so when I drive back to Atlanta, I'd have this all consumed.
I'm impressed with the depth of his analysis and weighing, the big picture, but I wanted to make sure that this has been vetted previously to today, so I appreciate you giving it to him and letting him screen it. The eviction chart that you showed that shows Georgia kind of a leader on that, on one way or another, depending on your perspective. What is the duration in Georgia that chart shows for eviction?
Oh, so this is an analysis, and I have one extra
Sure,
copy.
thank you.
I'm sorry, it's hard to make color copies up here. So this is a chart, and it looks at the statutory possibility, not what happens in real life, but for all states. And the reason, it does show that Georgia's tied for the third fastest in the country, but the reason I offer to you is because of these gold boxes.
Okay.
Those gold boxes are the notice period. And so you see Georgia has none. Now in Georgia, the landlord can tell you in the morning to depart and immediately go to court and file that eviction. And we know that the filing of an eviction alone will make it impossible for a family to rent that next home. That
All right.
record files them.
Real quick.
Yes, sir.
Georgia's not the worst. There are 5 states
Right, we're tied
that
for third.
have a shorter time frame than Georgia under your chart. But
Yes.
So you're tied for third, or you're the 6th,
Yeah.
depending on the chart. But the W-2, is that 2 weeks? What does W1, W2 mean?
Week.
So your chart says Georgia, you can get an eviction in 2 weeks?
It's a statutory time period.
All right. You would agree Georgia doesn't allow evictions in 2 weeks. All
None
right.
of these states. They're trying to compare what's in the statute.
The boxes that are on there, the 9 boxes, is that 9 days?
Right.
So
Yes.
you would agree evictions aren't happening in Georgia in 9
Yes,
days?
sir. I'm not offering
All right.
it for that.
I
I
tried.
actually would say they sometimes are.
Well,
I've seen it in my practice.
Well, and that brings me to that question. I asked the marshal, so let me ask you. In Metro Atlanta, Gwinnett, DeKalb, Fulton, Cobb, what is the duration today from writ of possession to a scheduled appointment to get the eviction carried out?
These are the experts.
Sure.
So I would tell you, DeKalb is still behind.
What's behind? If you have a writ of possession and a moving crew, what is the going duration of scheduling an eviction?
I can't tell you the number in DeKalb as of today, but I know Mr. Williams could.
Okay.
What I can tell you is I had a colleague tell me that 1 week from the writ of possession being issued, the next week the tenant was out. The marshals
That's
were there
one
and the
time,
tenant
but
was
I'm
out.
asking you typically, what are landlords hearing when they get a writ of possession on the scheduling if they have a moving crew?
It typically
Metro
has been,
Atlanta.
I'm sorry, that's me. It typically has been a few weeks. So
Typically over time, but I'm asking now.
I can't give you a number of what's typical without having some,
Some context
some
right
context. But I can tell you that a week has happened recently since the pandemic in Gwinnett County.
Well, but Gwinnett, if at least as of November, right before the session started, the earliest you could get an appointment scheduled for an eviction, if you got a writ of possession in November and you had a moving crew, was March. Isn't that true?
That's not my understanding. no.
Okay. We'll hear from the practitioner. Do you do what level of volume do you do on evictions in Metro Atlanta?
I probably do about, maybe 40, 50 a year, 60 a year.
And what is the range? You mentioned 1 week is one example, but what's the range these days of scheduling of evictions after writ of possession?
These days,
Yes.
I mean, it depends on the county. So
Okay.
I think in DeKalb, they are scheduling them slower, without a doubt. What I used to tell clients when they would contact me and say, what can I expect? How quickly will I be out once that writ of possession is signed by the judge? I would typically say, because I'm trying to give them the best estimate I can so they can plan their lives, is 3 weeks.
And
3 weeks was about the average.
The right to cure, a lot of leases say once or twice in a 12-month period, notice and cure. Are you advocating for right to cure every month?
So I think that landlords are going to need some uniformity. You can't have a different process for everyone in the apartment building. I know of no state that, we have a right to cure now after the eviction filing in Georgia law that's limited to 1 time a year. It's a 7-day period after the eviction is filed, and my understanding is that people are rarely able to avail themselves of the benefit of that. And of course, you've still got that eviction filing on your record. And so we're asking for Georgia to come in line with the rest of the country, what's been the law for many, many years, in a way that's not going to unreasonably burden the landlords. What we have been told in advocating about this issue over 4 years is that they already do it, and they're reflecting in the grace period that's maybe 5 days, 4 days, that they complain about the time it takes to get the eviction effectuated. You know, if it is a year, then adding a few more days is not really going to be material. And the final is that they say it doesn't impact the person's ability to rent the next home. And all of the research, Mr. Chairman, from the Federal Reserve to the national housing organizations to the people on the ground will tell you once that eviction filing is on their record, it becomes virtually impossible. So this is just a small opportunity. 7 days is not too long. It would be impossible for any of us to move out and find a new apartment in 7 days. We want to give people the opportunity to stay healthily and stably and safely housed.
Okay.
That's what this bill is about, and we're just trying to help perfect it.
I got one more question. Representative Stoner.
Thank you, Mr. Chairman. Remind me again real quickly, you were telling me as it relating to the habitable, the definition of which states are joining us?
Oh. So every state in the country has a warranty of habitability except
Right.
for Georgia.
Except for Georgia.
Sometimes if you look at the surveys, they say the statutory duty of the landlord to repair, they count that as a warranty of habitability, but the author doesn't consider it and no lawyer does. So the states that have I was pointing only to the southern states that we regularly refer to in this room. The ones that I have in front of me are Alabama, Florida, Kansas, Kentucky, Mississippi, North Carolina, South Carolina, Tennessee, and Virginia. But states across the country have adopted. I think it's 29 states.
And Elizabeth, thank you for that. And I don't know about members of this committee. I've chaired a development authority, South Dakota Redevelopment Authority, and I had the unfortunate thing we bought a rundown apartment complex over in the Six Flags area, and the condition of the apartment complex once we got in there, I didn't need a definition, but it's too bad we didn't have this definition, because what was definitely clear was not inhabitable. In fact, we had 146 units. We had 90 units occupied. We had to move people in the short term because these conditions were just unbelievable. And the county tried to do their code enforcement and everything. But the fact that, and this was back in 2015, eventually we had, we eventually bought the apartment complex to remove it because it was in such horrible condition. So the point of that is, and we had to do an eviction. So I'm very familiar with the process of eviction, because we had people who stopped paying, and I knew we were eventually moving folks out. But my point was, in the process, now what we ended up doing was we were trying to give people time. And to your point about giving people time, 7 days, even 14 days can be. I'm a landlord. I'm a property owner. I'm a landlord. I've evicted people. Heck, I even evicted one of my uncles by marriage, by the way. That's another whole story.
Bad story.
Yeah,
That makes a great Christmas card.
There you go. All right, yeah. Did that in 17 days. But my point is, we don't talk to that uncle anymore. But my point is, I think this issue here, because of my own experience, is crucial. Because, and nothing against the judiciary, and to the chairman, I don't know why we want to wait for the judiciary to figure this out when it's part of our job to define these issues. Not wait for the appellate court or the Supreme Court to make this decision. I just don't see why we don't go ahead and do that in a sense. I mean, with all due respect, if Mississippi and Alabama is my point, I don't know why, again, no offense to judiciary. Let's make their job a little easier in the sense of let us go ahead and define this now. And so, that's just my point. Is I appreciate this being brought. I appreciate the author. Appreciate a lot. I know this is very detailed, a lot of work. I'm just concerned that we're going to miss an opportunity, to your point, and wait another 20 years And my own experience says we don't need to wait. We need to go ahead and define this now. I'd rather us work on that and get this right instead of just, saying, well, we'll get to it another time. Because I've been here before, and I've been here long enough, and another time could be another decade. Anyway, I'm done, Mr. Chairman. I appreciate it.
Okay, thank you. All right, ladies, thank you. Appreciate it.
Thank you. And I would say I should have started off with this, that I think the intentions of this bill, and unfortunately the author just stepped out, I think the intentions are there. I really do, and I appreciate that the committee is taking up this issue. It's incredibly important. It affects a lot of people, not just low-income clients, but a lot of people in Georgia. So, thank you.
Thank you.
Thank you. Thank you.
All right, Hayden Stanley and friends, I'll call y'all up at this time.
Thank you, Mr. Chairman, members of the committee. I know many of us have spent a lot of time in this room together talking about landlord-tenant issues, so thank you for doing it again. I have Jay McGinnity, who's Vice President with Perennial Properties, is a practitioner, and he can speak to the way that it really happens. And Mike Williams, an attorney who represents a number of property owners in the state. He's counsel to the Apartment Association as well. My name's Hayden Stanley. We're proud to represent the Georgia Apartment Association.
All right, gentlemen, if y'all have a seat, please.
You're in the hot seat.
I had to go to the bathroom. That's heavy stuff, man.
All right, gentlemen, if you'll introduce yourselves and then tell us what you want us to know.
Sure. Mr. Chairman, my name is Mike Williams. I practice here in Atlanta, Metro Atlanta. I've been practicing for 29 years. It'll be 30 in October. My specialty is I do residential and commercial property litigation, primarily residential. I've represented owners and managers for the entirety of my career, ever since I was a baby lawyer and actually had red hair, which is now unfortunately gone. I appreciate you giving us the opportunity to be here. I'll let Jay introduce himself as well.
Hi, thank you, Commissioners. My name is Jay McGinnity, and I'm with Perennial Properties. I also serve on the Apartment Association's Governmental Affairs Board. Our company owns and manages over 2,000 units here in the metro area. And I've been serving on the board for a little over 4 years. And to an earlier question, it is just about a year to get an eviction in Fulton County right now.
And I concur with that. It's the eviction situation is pretty bad in Metro Atlanta. Gwinnett is probably better than most if I had to rank them. DeKalb can take up to 9 months to get, even in a year to get a set out. Fulton, the same thing. DeKalb's hearing cases from October of 2022. Fulton's hearing November and December 2022 cases. So it's fairly a little bit of a crisis state for the owners and managers, because when the eviction crew does come out, a lot of these apartments are full because they're not out doing set outs. So
let me ask you, to try and move this along a little bit. Lieutenant Buck spoke about resources. If we were to adopt this bill as written, what's your experience with the resources out there?
That's what we always hear from the Marshal's Department and Sheriff's Department when we meet with them about problems, about, why we can't get this moving a little bit faster, is they do indicate that it's a resource issue and they don't have enough sheriffs or they don't have enough marshals to perform the set outs. And to go to your earlier question, there is a specific statute that only allows the sheriff, the marshal, and the county to perform the set outs. So it's not like we can go out and contract with a private company to do it, and the intent of that is well served, which is to protect the safety of everyone when an eviction is done.
Yeah, you need somebody with arrest powers.
Correct.
Yeah.
Correct.
Okay. All right. Any changes that you see need to be made to the bill?
I do not. I have some. Let me kind of address it. I think the habitability section does not need a bunch of expansive definitions like that's been proposed. One of those proposals would be to allow somebody to withhold the rent for repairs. Most of our cases that we handle, for example, a good bit of portion are non-payment cases, and there are no defenses for repairs, and theirs is a percentage that are, and we address those. But if you allow withholding of rent for repair issues, you're going to see in a substantial amount of cases repair issues being asserted. That's going to change. It's probably going to flip-flop from I was unable to pay the rent to failure to repair, and we're going to see an abuse in that area of the law. So although we're in favor of habitability, we certainly are, members are at the apartment association, and my clients are that I represent. It's how you go about it that's important. And of course, the judges would determine that, and they do today. If they determine the premises in such a state and the resident moved out, under Georgia law, that's a constructive eviction, and there would be no future liability for rent. And that's well established in the case law. There's a lot of remedies now that we have, and to go back to the Go ahead.
I was just going to say that as it was written, as we read it, I feel like the criminal aspect, that portion, if anything, hinders our industry rather than help it. Just as a catch-up, we already have the ability to go forward with an eviction and put forth an eviction based on criminal conduct, not a charge, not a filing. The only thing we were at, or rather, the only thing that I thought this bill did, which was to everybody's benefit, was allow us to expedite that process. Again, hearing it's a year to get an eviction in Fulton County. I realize that'll truncate down, but there is a lot of tension out there with residents, with staff. There's a lot of burnout. Specifically in the metro, there's been a lot of criminal activity, and the landlord community is feeling a little bit hamstrung. We have the liability and the duty to provide safe premises and to protect our residents, and we are enduring situations where criminals are occupying units. We are unable to affect getting them out. The majority of the criminal activity on our property is stemming from fraudulent applications that get through and we're unable to get out. That leads to party houses, that leads to drug houses, that leads to flop houses. And again, all the while, we are being charged, or rather, we are seeing our contemporaries charged in lawsuits where just runaway verdicts are creating enormous problems from a liability standpoint for us. And, you know, we were looking at this on an expedited fashion, or rather, we thought this was a nice little carrot to us on an expedited fashion to get to a safety standard. We make money by collecting rent. Nobody in my industry likes to or wants to go through an eviction. I would imagine that the bar for the majority of landlords would be extremely high to put forth an affidavit to try to move forward on this expedited process. And I would gather that when we're doing it, it is usually for something we feel is incredibly severe and pertinent. I appreciate wanting to protect people, but it was hard for me, or a juxtaposition, to believe that we would try to take advantage to get to a quicker eviction. Again, our goal is to collect the rent. So as it is written, or as I saw in the substitute language, I actually believe that this creates now an added burden of liability to a landlord, because now I need to have somebody on my staff checking my rent roll and checking convictions or charges off-site, off-property, to ensure that if somebody was charged, that I am sort of diligently filing through a expedited eviction, or I'll face the lawsuit later. That
would you prefer the Section 6 of the bill be stricken?
Is that the? I mean, I certainly would appreciate the opportunity to try to work through getting to an expedited eviction stage for criminal conduct. I think I would like to see the language modified if possible, similar to an early draft, where again, the remedies that we already have and the ability to file for eviction already allows us to use criminal activity as a premise, as a guise. I'm fine with that being a very high barrier on an affidavit, and fine with a judge, reviewing that to determine whether that warrants an expedited eviction. But, if if it's all or nothing, then yes, this language as written, I think, creates more of a burden on a landlord than provides any sort of benefit for the landlord or community.
And I would agree. I think our focus is on the criminal activity. We can't always get an arrest or get charges filed. I've had instances where a gun's been pulled on a maintenance guy when he comes in, and we can't get any charges filed or an arrest. And so in that scenario, with this language, we would have to go through the normal eviction process and terminate the lease, send a demand letter, and go through the 9 months case, which we have right now. Case is pending where we've terminated lease based on criminal conduct, and we can't get them into court. So that is one of our concerns.
Our hope, sir, is that that language could be modified in a way that is closer to the original legislation.
Do you have any idea of language now?
Yes, sir, on line 84, perhaps strike next to the letter A charge or conviction for a crime in the previous 6 months, and replace it with any act that threatens the health, safety, or welfare of the other residents, the landlord, or that landlord's agents, employees, or contractors.
Not even a criminal act, not even a criminal charge. I'm sorry, Mr. Chairman. Any act?
Any criminal act. The key is that threatens the health, safety, and welfare of the other residents.
There's going to be judicial oversight on it.
So criminal act, yes, on the fly. That's what I came up with.
Or you want? Okay. Representative Reeves.
Now that I've gotten a chance to look at the chart that was presented to the committee, it looks like California is at 4 weeks for a tenant to be evicted for falling behind on rent. New York is 6 weeks. Massachusetts is 8 weeks. Massachusetts is the longest. In your experience, in recent months or years, is there anywhere in Metro Atlanta where you can count on getting a tenant evicted within 8 weeks of a writ of possession?
Absolutely not. It's impossible. It's the way the system's moving right now. It's impossible.
Representative Smith, Chairman Smith? No? Who's got 17? Oh, Representative Hawkins.
Yeah, thank you, Mr. Chairman. I'm listening to everything that's been said, and I think most of what I heard from your explanation, which I absolutely understand and appreciate where you're coming from, which is that you're representing good actors, and then you're dealing with good actors as landlords, and then you're dealing with bad actors as tenants that you want to move on from, whether it's for non-payment or other activity. What I'm wrestling with is the reason why we're here, which is the highlighting of issues where there are bad actors as tenants and people are living in conditions that no person should be living in. And sorry? The bad actors as landlords, yeah, if I misspoke, I'm sorry. Where there's massive mold, where there's lack of safety, where the living conditions are ones that nobody should be in. And it's what we're trying to do is strike a balance to, one, prevent that from happening, and then two, provide a remedy for those that are in those situations, which I think most people would agree are those without a lot of resources, without access to lawyers, and really for whom the deck is largely stacked against them, to give them some possibility of having hospitable living situations. And so I hear you in terms of if you have a self-help aspect that could be abused, but these people I think are being abused now. And I don't know that the bill as written provides enough help for them, which is what we're trying to get to. In other words, I want to be supportive of something. I want to do something that's helpful. I think we all do. But I don't want this to just be a paper tiger that we're happy that we passed something, but then 5 years from now, all the people that are living in these terrible conditions that they should not be living in are still there. I don't want that outcome. So can you relay to me how the bill as it's currently formed will get us there?
Yes, sure. I'll happy to answer it. Thank you, Mr. Holcomb. So there's already remedies in Georgia law that can be used in conjunction with the habitability clause, meaning we already have two statutes, 44.713 and 44.714. 44.713 is the landlord's duty to repair, and 14 is the tort statute that would allow a resident in an apartment where the premises is not repaired within a reasonable time after notice was given to seek damages of attorney's fees and punitive damages for those types of claims. We also have repair and deduct. There's lots of case law on it that has defined those statutes, 44.713 and 14, that allows a resident to give notice to the landlord, give the landlord a reasonable time to make those repairs, and then when those repairs are not done, they can pay to have that repair done and deduct it from the rent.
What's a reasonable period of time under the cases?
It varies on how serious it is. If you have no AC in July, it's short. If you have no AC in January, it's going to be a lot longer. It just depends on how vital that repair is. Obviously, a leak with mold would be one of those where it's a short window where you would need to go in and they would need to do it in short order, which would repair and remediate.
Okay.
And that's the advice we give our members and our clients is, look, the more serious the repair, and I think everybody would agree here, the faster you better get in there to make the repair, because you're talking about affecting someone's human life. So we understand that part of it. The other thing they can do is they can deem the premises to be uninhabitable. I think I mentioned this earlier, and the case law is well established. If it's deteriorated to such a point that it can't be repaired with them in there, they turn the keys in and they move. And in that case, that would cut off any future liability for rent and could hold them also to damages under the 44.713 and 14. So there are attorneys that file lawsuits for this. They basically will file a lawsuit alleging failure to repair under both those code sections, and they will assert damages, diminution in value, punitive damages, attorney's fees, those types of things. Fortunately, I don't have to get too involved in many of those. I have been involved in a few. Most of my clients that I represent, I crack the whip and I do a lot of training with them to make sure they understand the duty to repair is essential to the state. It's embedded in our code is a lot different than a lot like Alabama, who used the Uniform Act, developed it because they really didn't have any laws. So a lot of these states around us, they don't have the duty to repair and the code sections that we have to protect the tenants. We have an entire Landlord-Tenant Act, part of which protects the tenants from the duty for failure to repair. Other sections deal with security deposits. So it kind of breaks it down into what everybody's obligations are, as far as, the resident has a duty to pay rent, and we have a duty, meaning owner-manager has a duty to make repairs. So I think this goes one step further as to damages, as to ensuring that the premises are habitable, and I am 100% in agreement the premises should be habitable. I don't want any client that's not making repairs to the premises, and nor do I want one that refuses to do them at all.
Right.
Can I get that code section? I hand it back. Did you want to? So I know we want to work through the bill, but I feel like the issue of and frankly.
Can you pull that mic over towards you?
Yes, sir.
Yeah.
We believe that the bill's language on habitability is appropriate, and something that I don't think you've discussed today in full is, in terms of habitability in Georgia, and I'm sure Representative Stoner recognizes it from his experience, but one, you cannot waive away the following rights, and Mike spoke to those in 13 duties tied to a landlord's repairs and improvements, liability for a landlord's failure to repair, ordinances adopted pursuant to Code Section 366111. 366111 is where we get into repair, closing, and demolition of dwellings unfit for human habitation. And it reads, any municipality or county may, by ordinance, require the repair, closing, or demolition of dwellings or other structures intended for human habitation, which are, as defined in the ordinance, unfit for human habitation, or which may imperil the health, safety, morals of the occupants thereof and surrounding areas. And then it goes on to list what that may include. Local government has long had the authority and the obligation to adopt habitability standards, and they have the authority to enforce those. So we're at somewhat of a loss why we're seeing these dilapidated properties when the local government has full authority to go in and ensure that those are addressed. There are nuisance laws that are listed as well. Here I'll have for distribution, these are Metro Atlanta cities and counties and the code site of their local law dealing with habitability.
Okay.
So anyway, just
Thank you. Excuse me. All right.
A couple more things on the right to cure provision. We think the 3-day, right now what they do as a practical matter is they send a late letter out and demand possession in the late letter, give them a period of time to pay. We think the 3-day notice is in accordance with that because most leases have a grace period. There are some landlords, a lot of smaller landlords that can't afford a grace period. An individual owner that has a single home, some of those don't, but the ones that we represent typically have a grace period, rent's due on the 3rd and late on the 5th. And so then if you're issuing a 3-day notice on the 6th, for example, now you're looking at the 9th. So we think that's sufficient amount of time for someone to pay the rent if they're going to pay it. We send the notices out now, and we're still filing cases. So it's not like even now with the way the practices in the industry that we're seeing, and Jay can probably speak to this, is we're still filing cases, even though we're given our own grace period, so to speak, the 3 days. So we think the 3 days sufficient. I will say that Florida uses the 3-day. I think South Carolina uses the 5 days. So the states around us vary on this issue. They go anywhere from 3 to 7. But Florida, the most, and is 3, and South Carolina is 5. So we think that's sufficient. Given we are already sending demand letters and we wait a few days to file anyway.
Yeah, I would concur with Mike. I think my other concern, just to note, is that, as Mike said, I think is an industry standard. Typically, you're getting 5 days to pay before you're late. The notice is usually going out a day or two after that. My concern would be that if this became too onerous on landlords, what you would see is sort of just a shifting within a landlord's own voluntary policy. I recognize that, we're looking for guardrails to protect against, the worst, but I actually would foresee a longer duration cutting into grace periods and, sort of doing away with any sort of period before a late fee. Or at least I think it would suck back commensurate with it.
Okay. And there's one more point. I think there was some talk about, let me find it. About what's contained in the 3-day, I think there was some talk about all past due rent, late fees, utilities, and other charges. And we can clarify the utilities. There's 2 types of utilities usually charged to the resident. One is water sewer charges. There can be some other utilities that are already paid for by the landlord up front. So those utilities are just being recaptured. The law's already clear that you can't charge more than what's being billed to the landlord. So we're really trying to recapture. We're not talking about if they've got a contract with Georgia Power and they don't pay their bill with Georgia Power. That wouldn't give us the ability to do anything except that they let their utilities turn off. Then we're concerned. But the utilities we're talking about are water, sewer charges, those types of utilities that are defined in the lease agreement and are due as additional rent. So most of these charges, the utility charges, provided for, and there could be other charges, a garage charge, all that's defined as additional rent in the lease agreement. So we would, if it just said rent, we would be a little bit concerned about what that means. It means, can they just come in and pay the base rent? What about all the charges that they'd agreed to under the contract? So we think that additional language is necessary.
Okay.
Actually, just one other thing while I thought of it. The group before us, there was a woman who pointed out that there's a fair amount of families that stay in extended stay hotels, paying exorbitant amounts for crummy conditions, and the only thing that's keeping them from moving out is the security deposit. I would just note that there is a lot of charitable groups, organizations, one in particular that our industry works with, Open Doors, that's housed over 9,000 homeless people and found them permanent supportive housing. One of the ways that Open Doors is able to affect that change is by providing oversized security deposits to landlords to have them provide units into the program, because otherwise the tenant in the program would not qualify. I believe somebody else had pointed out an eviction on your record becomes hard to rent. Well, there are groups, there are charitable groups, there are nonprofits that are working to help in a practical way. And one of the mechanisms and vehicles that they have used to do that is to supplement and augment larger security deposits. So I would caution. I appreciate what they said of that being a barrier, but I think somebody had mentioned the standard market is 1 month or less. I would just caution to limiting it to that, because the people we're trying to help the most, we may leave some of them out cold if there's no credit support enhancement mechanism to help augment a shoddy rental record or other credit issues.
Okay. All right. Representative Stoner.
Thank you, Mr. Chairman. To your point, what you were just making, and I'll just make this one. I'm just full disclosure. I've done stuff with Perennial years past on some stuff with the apartment association. Y'all are the good actors. I get to deal with the bad actors.
Understood.
Yeah, and to your point, when we had to finally take down that apartment complex, we started the eviction process just to begin the process. What we ended up doing was we went to consent orders, because we did not want to give these folks a bad credit rating, because that's what's going to happen. And so anytime they showed up to court, we worked with them and said, let's do a consent order. I just need you out by a certain time, mainly for their own safety. Yeah. But to the point that was said earlier, and I appreciate what you're saying, but I think we're still in the same situation. How do we deal with the bad actors? These are not members of your association last time I checked.
No,
yeah, exactly. I mean, I get that. That's my point. Yeah, and again, it's a balance, as Representative Holcomb said, of how do we protect? I mean, the same area that I'm talking about, they're charging $1,000 for apartments that are in very bad shape. And the county's gone in there and done everything they're supposed to do under that code ordinance. And I'm in Smyrna, and we've done the same thing. And we've condemned apartments and everything. But there are still limits to what we can do and everything. So the point I'm making is that I'm glad this legislation's come forward. I still don't think we're figuring it out, what the balance is. I guess my question to y'all is, you're saying you have issues or some changes and everything else. It doesn't sound like this bill is ready, is what I'm hearing from everybody. That there's still a lot of questions. You're talking about the 3-month thing. I heard that from Elizabeth, and about as someone, as a landlord myself, you start telling us it's 3 months. Well, you've just changed when you call the free market with competition. Well, we all can do 3 months now. So why don't we all do 3 months?
Well, I think the marketplace would tell you that you're
that may be
pie in
true,
the
but at some
sky.
point, it could get that way. I'm just saying. To your point, you've asked, don't put that in there. I've heard that from them. They don't put that in there. But I'm just saying, I'm not sure this legislation is quite ready to move. I think we have had a lot of questions about a lot of things here. I just, just a point I'm making, but I do appreciate y'all coming today.
Representative Stoner, if I may, he offered that observation about the way security deposits work. We have no objection on that. We don't think that it's going to impact those we represent. They do not typically, or I don't think at all, do that. It's been a minute.
Hold on. I didn't want to suggest I'm advocating for that. I just wanted to suggest that we have worked with charitable groups and nonprofits that use that to augment. And I know that's the most disenfranchised population is who we're trying to protect with this and the security deposits. And I just wanted to make note of that maybe that was what the bill sponsor had in mind, or, advisors of his, to not limit it too low as to not allow for any credit augmentation. But to Hayden's point, it wouldn't affect the vast majority of our membership.
And I should have started out with thanking the sponsor. You're trying to tackle an issue that, as we all know, is very complex. It's complicated. We're dealing with people's homes, and we appreciate your measured approach. We think it's an incremental step forward and is largely something that can work, moves in the right direction. We've talked about some language in the expedited eviction process that we would offer for your consideration, and tried to describe what the impact would be. But overall, please know that we're appreciative about this very serious and sober effort that Representative Carpenter is undertaking.
We're running short of time. Representative Evans, hold on just go ahead.
Thank you, Mr. Chairman, and apologies to you and the committee for having to step out. I had to deal with a family matter, but I was listening to y'all as much as I could in the car back and forth, I know we've been here a while. On the issue of the security deposit, I also don't like the idea of putting 3 months in there because I think could be very enticing for some people, and I also just think it's too much. I mean, you've got a year. You might be demanding a quarter of the time that the person's going to be there. That seems excessive. And I also hear your point about the nonprofit. So what my question to you is there anything, if we were to limit the security deposit to 1 month, I don't think that would preclude the situation you're talking about where maybe the nonprofit or someone sort of co-signs for the lease so that if there's a way for that person to make up the money that perhaps y'all see as enticing to allow maybe less creditworthy individuals to rent. And I just wanted to ask if my understanding was correct on that. That could be allowed.
I would be careful about 1 month because you've got there are some folks that are approved with conditions and it may require 2 months security deposit in order because their credit's not good and properties take a risk on them. And so they would require possibly, usually up to 2 months is what we see as sort of like the threshold on somebody that has a credit issue. But Lindsay's right. 1 month is the standard in the industry unless there's some risk issues, and then it could be more. So I would be a little hesitant to say 1 month would do it because I think then you could have a situation where someone would be declined when in fact who needs housing.
But I get all that.
Okay.
But the specific question about the nonprofit, nothing precludes y'all from having an organization like that as co-signers.
No, ma'am.
Okay, thank you.
No.
All right, gentlemen, just the bill as it is, y'all would be happy with if it passed? I know you have the criminal activity question. I'm trying to see how much work I've got to do here.
There's a wee bit of work.
All right.
I agree.
Again, just our perspective is it is largely workable for our members, but we would prefer to see the original language or something very close to it back in on the expedited eviction for criminal activities.
Okay.
So otherwise, I think we're...
Okay, well, this is going to be hearing only. We will take this up next week.
So excited.
All right.
Thursday afternoon.
I didn't want to do that, but.
No, what you talking about, man?
Representative Carpenter?
I don't even have the language on that bill. You got a copy for me? It's been a long day, man. I've been dealing with tickets and tenants, landlords, HOAs. What's left in the funds of today?
We're going to House Bill 355.
Thank you, Keller.
Yeah.
Might be go T Hackney, which I guess is probably lost.
All right, folks. I'm just going to briefly describe this bill real quick. I know everybody time is short. Basically, the gist of this bill, House Bill 355, is to make sure that in Georgia code that HOAs cannot ban solar panels or natural gas. Brought to me from a constituent of Devin Seaballs in Marietta that really wants to have solar panels on her house, but she lives in an HOA that will not allow it.
Second? All those in favor say aye. Any opposed?
No.
Got one opposed. All right, it passes. It's on to the rules.
Okay.
All right. House Bill 375. Representative Leverett, where'd you go? Did he bolt on me?
Chairman Gunner, I'm sorry, I had signed to speak on that bill. It sounds like it's not going to matter, but.
Are you sure you want to speak on the bill?
For my client had to leave. I did want to say one thing, but look, it's not going to matter. It's okay.
You got short-circuited there.
I did indeed.
All right.
You want me to speak to Representative Leverett's bill?
Yeah, if you want to.
Okay, got it? Okay.
Yes, sir.
Okay, committee members, this is House Bill 375, LC 44254. This is a bill that we passed out last year, which raises, basically the only thing it did, it raised the amount of settlement that a parent could do on behalf of a minor child without doing a complete guardianship on the case. So we raised it from $15,000 to $25,000, and this is a great thing. It saves a lot of work for the probate court judges. It also saves expenses from the parents of having to settle a case through probate court. Any questions?
So you've put in here the term gross settlement.
Yes.
That's what basically the bill does, is define that.
Yes.
All right. Any questions by the committee?
Second.
Yeah, all right. Any further discussion? We're about to vote on your bill.
I hope y'all voting to do pass. I'm not gonna say.
We did.
All right. All those in favor say aye. Aye. Any opposed? Bill passes. All right.
Thank you. I'm glad I was so stirring.
Okay.
I
We're
covered
done.
for you.
Thank you.